What's up? My name is Cameron Wilson. This is Operation Wisedome. Today is Sunday, June the 14th. Of course, Operation Wisedome is powered by power inherent in the people. Everybody, y'all unmute and say good, or Grand Rising world, or hello world, however
Grand
you want to say it.
Rising
Grand
Grand
world.
Rising.
Rising. Good
Grand
morning,
Rising.
everybody.
Grand
Hello,
Rising.
Yay.
hello.
I know
Great
the day
day.
now. Yeah, everybody say it now. Everybody say it now.
It is great. And thank God for this guest, too. I love what you do, Cameron.
For sure, for sure. Well, today we have a special guest. His name is Lewis Ewing. Um, it's pretty crazy how he reached out to me. I don't want to give out too much tidbits, but I did a Wise Dome session. He reached out to me. He wanted to relay some information. He came off very strong. I ain't gonna lie. He came off very strong at first. Had to calm him down a little bit. Had to simmer him down. Once we had to simmer down a little bit, we had an amazing conversation, and I couldn't do anything more than to bring him on in relation to his experience, his knowledge, and what he's doing, what he has done, and what he continues to do within our nation. So I want to welcome Lewis. Lewis, how are you, brother?
Pretty good. How are you?
I'm doing well, man. Yesterday, we had our 18-year-old finally graduate, and so congratulations. If y'all want to say congratulations, Romeo, y'all can. Shout out my boy Romeo. And yeah, we
Good
went
luck
to his
in life,
graduation.
Rome.
Good job,
Yeah,
man.
man. Yeah,
Congratulations.
man.
Congratulations.
Yeah, man. So
Major
pretty big.
accomplishment.
Sorry.
You got a
But
good view
yes,
of my head now?
yeah, we got a good view of your head. And
Okay.
so what? Yeah, so yesterday was kind of busy, but yeah, everything's been amazing, bro. Truly blessed. How about yourself? You're sipping on a coffee, ready to roll?
Yes, I am.
Okay.
Well, folks, my name is Louis Ewing. I'm 64 years old, and I've made my living undercutting attorneys and law firms specializing in helping only pro se litigants since the mid 1980s. I've advertised on the internet since 1989 that I don't file federal income tax returns. I don't pay federal income taxes. I don't pay Social Security taxes. From what I know, I'm the only man in the entire United States that's done that for more than 5 years that hasn't gone to prison. Well, at least not yet. Okay. I've also advertised since December 8, 1996, that I drive with no license, no insurance, no seatbelt, and smoke pot while driving, and so can you. And for you folks who don't know this, I'm the reason why medical marijuana first got legalized in Oregon. I did Washington second. I did Colorado third, recently Florida. Um, well, the government, they've only legalized about 20 something states. They're actually in a mad rush to legalize medical marijuana for all 50 states. Right now, they only have about 20 something states done, and they're desperate to get the other states done. They just can't get the legislators to move fast enough. I actually have an ultimate user flyer for about almost 40 something states now, where I put two state statutes side by side with two federal statutes that shows that marijuana is legal. It has been legal since 1973. Now, some people will say, well, you're promoting drugs. I don't like that. Well, I'm not promoting drugs. So I actually worded my flyer to make it look like it only applies to marijuana. But the truth is, the statute says controlled substances, which means my flyer works for all types of drugs. Okay. Now, you folks are interested in right to travel, but this is also helpful to people who have had their children taken by CPS. And it's very important for people who are losing children to CPS to know your rights on a traffic stop, because more and more parents are getting pulled over drunk driving and the kids are in the car. So instead of taking the kids home to the other parent, they're taking them straight into CPS custody. So it's very important for people who have problems with the child protective services. I call it child prostitution services, because they're selling children to same-sex marriage couples and Jeff Epstein's Island and all the other pedophiles. So it's very important parents learn their drug rights. And right now, you folks don't know this, but 40 to 60% of all parents who have a child in CPS custody is because they flunked their drug test. And I have the solution to giving back every single child that tested positive for a drug test. But let's go into a few more of my accomplishments. In 2004, I beat the largest multiple felony count prosecution for manufacturing marijuana in the entire United States. In 1998, I forced the former governor of Washington State, Mike Lowry, to convene an emergency special session of the Washington State Legislature to change the legal definition of money, codified, you want to write this down, codified at RCW 84.04.060. That's our state's property tax code, which used to define monies shall be held to mean gold and silver coins, gold and silver certificates. Because of the legal documents I had submitted before Judge Barbara Lindy, who at that time was the presiding judge for all the King County District Courts in downtown Seattle, and out debated her on the spot regarding a fine that she was hitting me with for finding me guilty for driving while suspended, which later got remanded from the Court of Appeals back down to the District Court with orders to dismiss, because they don't want a published decision with my name on it saying you cannot be charged with or found guilty of driving while license suspended if A, you've never had a license, B, your license is expired, C, you're not driving in a current state of suspension, D, the Department of Licensing does not have a proof of service that you were actually served with the letter, the notice of suspension, which contains a date certain that tells you when the suspension begins, when the suspension ends, and the date that you would be eligible to reapply for a new driver's license. They had no proof of service of that. And I've done extensive briefings on all these different levels of driving while suspended, and I've gotten people's charges dismissed, even though their license was suspended, on the mere basis that the state did not have a proof of service that they got that letter in the mail. Basically briefing out the due process clauses of the state and federal constitution, which includes notice and opportunity to defend. That's right. The annotated case law for the due process clauses of the state and federal constitution says you have the right to the due process of law, which includes the notice and opportunity to defend. So if they don't have a proof that you got the notice, you had no opportunity to defend. In fact, many years ago in Washington state, they illegally used to have a 30-day hold. Anytime somebody was driving while suspended, they illegally put a 30-day hold on people's cars. Well, I had a guy who was behind in child support, and this was in Mason County. The fat lady judge told the guy, I've never done this before, but I'm going to order the state patrol to pay for the 900 something dollar impound. And that was just awesome, sticking it to the state patrol. I was jumping up and down happy about that.
Yeah, I would be too. Okay, keep going. You're good. I don't want to interrupt too much. Go ahead.
So also with the mask mandates, they tried to murder me over the mask mandates. I had actually drafted a flyer that I put out for free to all 50 states using each state's criminal code and each state statute showing how the mask mandates were illegal. It was a violation of the separation of power doctrine. And in every single no mask required flyer, at the very end, I put the governor's proclamation statute. Most people just totally skipped on by this. This is so important. The governor, at the stroke of a pen, has the power to shut down the whole state.
Mm-hmm.
But there's no perjury, Jurat.
Mm-hmm.
There's no accountability in his statute.
Right.
That doesn't make any sense, because even the lowest meter maid or the cop giving you a civil infraction, at the very bottom of that yellow the green ticket for infraction, even the yellow for criminal, it says, I certify or declare under the penalties of perjury. Here in Washington state, they use the unsworn declaration statute. But when you look it up, the RCW 98.7, was it 70085, I think it is, or 7285, it says, I certify and declare under the penalties of perjury. All the above in my report on the back of this is correct and true.
Right.
Well, there's no perjury, Jurat, on the governor. So guess what I did? I started looking through the statutes, and I discovered, okay, perjury. In Washington state, second-degree perjury is when you put a materially false statement in writing with intent to mislead the trier of fact to make a ruling one way or the other based upon what you put in writing.
Right.
First-degree perjury is when you lie in open court and you get caught.
Yep.
The forgery statute, now that's a unique one. The forgery statute has definitions, what they call a complete written instrument and an incomplete written instrument. So that governor's proclamation, it's a complete written instrument under the definitions of forgery that contains everything it needs to be a proclamation of a pandemic, but it's an incomplete instrument because it's missing something that's required by law to contain, and that's a perjury, Jurat.
Right.
Okay, and also a finding by the state health board that this so-called pandemic is a naturally occurring virus or bacteria, or is it a biological weapon? Well, they didn't want to do that. None of the states did. Not a single state had their state health board test the COVID to see if it was a real naturally occurring thing or if it was a biological weapon, because plausible deniability. They don't want to know. Okay, that way the governor, in good faith, can put his stroke of the pen down and shut down the whole state. Well, that violates another statute, and it's a felony in every single state. And I went on Stu Peters' segment on the Alex Jones InfoWars to talk about this problem.
Now wait,
And
now wait. What I wanted to show is, I actually seen that, and what I wanted, where's that at? Down here. That's you right here. Yeah, let me see this.
You are a seasoned pro se litigant, a citizen litigant who has helped many, many hundreds and thousands of people in court. So bottom line is, you're saying that governors, state representatives can be held not only civilly, but also criminally responsible. And then also, if they should lift the mandate, then actually lifting the mandate becomes a criminal offense as well. Is that right?
Yes, every state has a statute called concealing.
Can't make
When these governors that remove the mask mandates, the concealing statute uses the language, the very similar language. When you withdraw something from a public record, when you remove something, you cancel, you withdraw, you destroy, you obliterate, you hide, you obfuscate. When you get rid of something in a public record, a document that's been filed in a public record that contains evidence of an underlying felony crime, you just committed a separate felony crime called concealing.
My boy, look at you on the Alex Jones. My man. All right, keep going. I just wanted to show everybody that you're a real deal out here.
yeah, and it was literally within a couple months of that broadcast, I woke up in the Auburn intensive care unit to find out that I had been put into an involuntary coma, and that I was on an old style mechanical ventilator. And probably the only reason I'm alive today is because some lady friends in Oregon called up Stu Peters again. And so he put a shout out nationwide, and the Auburn intensive care unit got flooded with thousands of phone calls, for Louis Ewing. None of the other patients could get their calls. None of the doctors or nurses could get their calls. I mean, there were thousands of people from all over the United States and even people from other countries all over the world, because, his show, Stu Peters' segment on the Alex Jones InfoWars goes worldwide. And even the hospital couldn't run its normal hospital business. So they finally caved in and removed me from the ventilator. And I came to. I immediately came to. I have a strong body. I was a crab fisherman for 13 years in Alaska. I made my living pushing 700-pound crab pots across the decks of Alaska and the Bering Sea, based out of Dutch Harbor, 13 plus years. Plus I'm a former amateur and professional kickboxer. I used to be the main sparring partner for Maurice Smith from 1980 to 1994. Maurice Smith, for you folks who don't know this, he was the longest reigning champion in the sports history of kickboxing as the WKA World Heavyweight Kickboxing Champion. He won the Battle Cage, he won the Extreme Fighting, he won 2 K1 Kickboxing Championships, and he won the UFC 14 and the UFC 15. So look that up, UFC 14 and UFC 15. And, at that time, I was 155 to 160 pounds, and Maurice once told me, "You're the only guy in the entire United States that make me sweat, during a spar session working out." And I was really proud of that, because I was a middleweight sparring a heavyweight. That's kind of a big thing,
All right, so check it out. When we have you over here, we have the lawyer who actually will fight for you. Federal and tribal law pro se advocacy. Federal bar member. How do you get a federal bar membership?
You have to be a practicing lawyer for at least 5 years. And so I used to live on the Muckleshoot Indian Reservation, and you have to be part Indian unless you're a member of the bar. Okay. But I'm a quarter Apache Indian myself. And one day, a good buddy of mine, a guy named Willie Murphy, and he told me, "Hey, I need your help with a traffic ticket." And I said, "Where are you at, Auburn or Kent?" He says, "I'm here in the tribal court." And I'm like, "What? I've lived here for 2-something years, and there's a tribal court here?" And I go, "Where's it at?" And he says, "It's among the administrative buildings." Well, the Muckleshoot tribe, they're huge. Okay, they have so many administrative buildings, you'd think you went to South Center or Northgate Shopping Mall. Massive buildings everywhere. I said, let's go check it out because I knew it wasn't 5 o'clock yet. So we get to the courthouse. The court clerk said, "Well, court's not in session, but the court's open. You can go in and look at it." So I walked in there. We both walked in there together and go, "Man, you guys got a lot of money. Your court is nicer than the Seattle Municipal Court." I said, "This is going to be fun." So I filed some motions, and we thought it was our judge buddy that we go get drunk with and that we get high with. I think this ought to be a piece of cake. Wink, wink, Your Honor.
Yeah.
I thought I was going to have an easy time because, I can't say his name. He'll get mad at me.
Yeah.
But it was a tribal judge. And so we go into court and we see a white lady sitting at the desk, and I'd never seen her before. And she's glaring at me with the mean, mad dog eye. And I looked at my friend Willie. I said, I don't think this is going to go well. Right when we walked in the courtroom, it's a Judge Carolyn Dimmick. She's a former state superior court judge. And the unique thing about Carolyn Dimmick, she also happens to be a United States District Court federal judge. And even more than that, she's the judge who wrote the findings of fact and conclusions of law for a famous case in Washington called the Hagen escrow case. The Hagen escrow case went into more detail than any other case in the state of Washington as to who is qualified and who is not qualified to engage in the practice of law. Well, that's the judge who first authorized me to practice law. Okay. And they've since changed the rules since I got authorized to practice law to make sure. And I suggested, it was at my suggestion too, because I told them there'd be a bunch of dummy sovereign citizens trying to hang up a shingle and pretend to be a lawyer when they don't know jack shit about law. But we'll go into that later on another show about, beware all the scammers.
Mm-hmm.
So anyway, she goes, Mr. Ewing, the first thing I'm going to tell you right now is that state law doesn't apply in this courtroom. And I said, well, thank you for the dismissal, Your Honor. Could I have that in writing? And she screamed at me again. That's not what I said, Mr. Ewing. I said state law doesn't apply in this courtroom. And I said, Your Honor, I've never met you before. I haven't been disrespectful. And you're shouting and screaming at me in front of this entire courtroom. And I have no idea why. But I'm going to thank you for that dismissal. Could I have it in writing?
Yeah.
She got mad. Her face was boiling red. And she goes, Mr. Ewing, what are you talking about? Well, Your Honor, my client was charged with RCW 462342, driving while suspended. He's charged with the RCW for drunk driving. He's charged with the RCW for resisting arrest, the RCW for obstructing, the RCW for refusal to cooperate and give information, and the RCW for not wearing a seatbelt. Those are all violations of state law, Your Honor, and you've yelled at me and screamed at me in front of this courtroom several times that state law doesn't apply in this courtroom. So now could you please put that dismissal in writing? She slammed her gavel, declared a recess, and she ran into the judge's chambers.
Mm.
The court clerk and the prosecutor followed her into the judge's chamber. She came out about 10 minutes later, and she apologized. She said she wanted to apologize to me for the judge for yelling at me. She told me that she's never lost her composure before pro se litigant ever before in her history of her legal career, but I'm the first person to outsmart her. The only person to outsmart her. And she goes, you're really good at this. And I read your speedy trial brief. It's the best that I've ever read. Where did you go to law school? I said, well, actually, I started attending law school, pre-law at the University of Washington, but I decided not to follow through with it because I figured out all the attorneys are crooked.
Facts. Well, a lot of them are, man. I've now you said Mary Dimmick or
Carolyn Dimmick. She recently passed away.
okay.
She's a former state superior court judge. She also happens to be a senior, was a senior United States Court federal judge.
Do you spell it Dimke?
Dimmick.
Okay, never mind. Man, I was like, dude, that is very you made it sound like the way that it sounded was almost very similar to the United States federal judge that I have working on my.
Oh, Dimke. Yeah.
Yeah. So I was like, no way, bro. I was searching. I was like, let me find it. This is crazy. Okay, keep going.
Judge Carolyn Dimmick. So anyway, the prosecutor asked me to join their tribal court. She said, "We reviewed your documents," and she said, "You're like in the top 2% of everything." The judge said, "You're in the top 2% of all the legal briefing." She said, "You're more than competent." Like, she was curious where I went to law school because my documents are that good. And she said it was the best speedy trial brief that she had ever seen. And anyway, she invited me to join the tribal court. Now, I'm not going to go into full detail, but basically, she said once I had completed this process and whatnot, that I could come back into the court and that she would swear me in. Okay, so I purchased a copy of the tribal code because they wanted me to become familiar with the tribal code. At that time, it was only like about like a little bit over a ream. And I said, well, I can't read a whole ream of paperwork, right now. And it'll take me a couple weeks because I'm busy working on cases. And they said, okay, we'll schedule you to come back in next month
Mhm.
to get sworn in. And so I go home and I read the tribal code. I discovered why that judge was so anxious to authorize me to practice law right then and there, because she deemed that I was already competent. And that's the first thing for people who want to try to copy me. Don't think you're going to do what I do. Don't think you're smart, because the attorneys can spot somebody who's a dummy in half a second.
Yep, and they'll
Okay.
run right over that too, right? As soon
Yeah.
as they notice that you're mentioning something that you're not familiar with or that they will stay on that until you falter and fail, and then you're put in a situation where you don't know how to move the court in any form or fashion, or hold them responsible for their illegitimate decisions and or rulings at that exact moment. You're exactly right on that. So,
Well, think about this. Do you want some dummy going to your mother, your father, your grandma, saying, "I'm a real lawyer. Here's my bar card. Give me $10,000."
right, right, for a
You
fact.
know,
Yeah,
and they don't know anything, and they're
yeah.
just ripping off your grandparents. I don't think anybody would like that.
No, not at all. And
So,
okay, go ahead.
anyway, I discovered that night, and I kind of lied a little bit, and that because she wanted to swear me in right there, and I don't get scared. Like, I've been in gang fights, I've been in bar fights, I've had Filipino gangs pull balisong knives on me in a bar. I've had people pull guns on me. I don't get scared to fight. I love fighting. I'm a former fighter. But there's two things I'm scared of: is a judge being nice to me and a doctor in white robes.
Facts.
Okay. The doctor, number one. Judge, I don't really give a shit about. Okay. But if they're offering to give me something nice, like, we're going to swear you in to practice law, like, whoa, 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 why are you so anxious? So I read that night that says that the judge in a tribal court had the authority, contempt power, to summarily throw your butt in jail for 14 days and hit you with a $400 fine right away. So, yeah, if she had sworn me in right there, she would have thrown me in jail for contempt of court.
Right,
I
correct.
think it was minimum 10 days the first time. Um, so I looked in the judge's policy and procedure manual, which, by the way, I have all the judge's bench manuals for the state of Washington. So I went to the section of the judge's bench manual. It talks about contempt of court. And it says that everybody is entitled to due process of law to have a contempt hearing before a judge can throw you in jail for contempt of court. So I cited that rule when I filled out my oath of authorization. I put, I reserve my right to a contempt hearing as stated in the Washington State Judge's Bench Manual. I even cited it by the page, and that alerted the judge that I have their judge's bench manual. And she goes, "Mr. Ewing, I'm not going to sign this, and I'm not going to authorize you to practice law unless you draw a line through this." So I said, "Okay, Your Honor." I drew a line through it and put under TDC, threat, duress, and coercion. And then she proceeded to swear me in to practice law. So I actually have an oath of admission from the Muckleshoot Tribal Court, the Tulalip Tribal Court, the Lummi Tribal Court, the Puyallup Tribal Court, also out here in the Quinault Tribal Court. I'm a member of the American Bar Association, the National Native American Bar Association, and the Federal Bar Association. But with the Federal Bar, uh, um, they require that you be a practicing lawyer, that you submit evidence that you're a practicing lawyer for a minimum of 5 years. Okay. The American Bar Association has two different levels. Anybody can join it as like a mascot, and pay for a membership because they like getting money. You get their magazine, you subscribe to their magazine, they'll make you a mascot member of the ABA, but you're not a lawyer. A bar card is not what proves that you're competent to practice law. A bar card is just a membership uh, um, that memorializes the fact that you were authorized to practice law at some point somewhere by some judge in a court of record. So anyway, um,
Hey, one question for you.
yeah,
Jeremy asks, is the bar, does the bar mean British accredited registry?
no, that's a sovereign citizen myth. If you do the real study on where the bar comes from, it was actually originated in Athens, Greece. So that's just another conspiracy that doesn't hold any water
Good.
at all. The United States is separate,
Well, then
or
what
some
is it?
people.
What is
United,
bar?
the United States, the bar. I mean, it's nothing more but a loose knit of private, nonprofit LLCs. Like here in Washington State, the bar is a nonprofit LLC. It's not part of the state. I actually did a bunch of research
Well, what
on
does
the
it
state bar.
stand for? I'm just curious. Bar means what? They're letters. It's an acronym that's all capital, or maybe it means nothing. I don't know.
Well, it's an association of bar attorneys, but it's not British. We are not British. Unless you want to say United States is part of England, and we're going into old history a little bit off track there, but a lot of people don't understand this. But the Virginia Company, which was owned by the Queen of England, defeated the states in original jurisdiction, what you call the Old Union, the 13 Union states. Okay. And once the Queen of England defeated us, they ordered all the old states in the old union to put new constitutions into effect for the new union. And the way to discover the proof of that is for all you folks to Google, look up the Reconstruction Acts. Well, the name by itself so tells you what are they doing? They're putting back something together they destroyed.
Right.
The fifth article of the Reconstruction Act tells all the states that they're supposed to put new constitutions into effect for the new union. Like I said, I'm 64 years old. I've been at this for a while. But I revealed to all the patriot groups in the United States in the late 1990s that every single state has suspended their first original de jure handwritten constitution. Every state has two or three or more constitutions. Arkansas, Alabama, uh, um, and Michigan has four constitutions. Texas has five constitutions. Washington State, we have the 1878 Walla Walla Constitution. Okay, that was our first constitution. Um, but in George Meany's autobiography at the George Meany Law Library, I read his book, and when I read a section there, it says they talked about the 1878 Walla Walla Constitution, and he lied in that book. He says Congress failed to ratify it, which was half true and half false. So I decided to look it up, and I looked in the congressional records, and I spent time in the archives office of the Secretary of State's office in our state capitol. And I discovered that the 1878 Walla Walla Constitution was actually presented to Congress. It was rejected the first time, okay, because he didn't bring it with him. He didn't bring an actual copy of it with him. So he realized he'd screwed up. He went back to Washington State. Back then we didn't have internet and telephones, and they traveled by train. So they went back the second time, and he presented it the second time on January 28, 1889. I discovered that the 1878 Walla Walla Constitution is the one and only Washington Constitution that was presented to Congress on January 28, 1889. It was ordered to be published 50,000 copies. It's in the congressional record. And what we're currently using right now, the RCW Constitution, which used to be in volume 0, they got rid of it because we used to make fun of it in court that it means nothing. That's why the Constitution's there, because it's a fake Constitution. Um, so I went to DC after I'd gotten copies of it to do some research. And I was the head of the legal research team. We had Kurt Riggin, Lloyd Smith that I picked to go with me, and also a guy named Tim Duffy. So I picked those guys to go with me to Washington, D.C. to do research on the constitutions. And I discovered that every single state had suspended their constitution. At that time, the head of the National Military Archives, a man named Rodney Ross, he's retired now. We were in the rotunda, which is a horse-shaped building. You folks aren't going to believe this, but I almost got arrested for reading the Constitution.
That's crazy.
So you enter the rotunda on the left door, and it goes up to the top of a circle. It goes to the right, and there's like a sets of steps that goes up like an amphitheater around the Constitution that's on display. It's only 4 pages. So I took a step up, and I stood on the side of 4 pages. That's it. It's only 4 pages. And so I'm reading the Constitution while everybody's walking by. A military guard in black fatigues with like an AK strapped over his shoulder came up to me and asked, "What are you doing?" Now I'm dressed in a suit and a tie. And I said, "Well, I'm reading the Constitution." This guy says, "The Constitution's not to read, it's to look at. Move on." And I said, "Sir, I'm not blocking anybody's way. I'm reading the Constitution." He said, "Sir, if you don't move, I'm going to place you under arrest." So I whipped out my bar card. I said, "Sir, I'm a federal lawyer. Do you want to be on the front page of the local newspaper, uh, admitting that you arrested somebody for reading the Constitution? That you said the Constitution is not to read, it's to look at." And then he politely humbled himself a little bit. And he said, "Sir, I'm doing my job. And if you don't move, I'm going to arrest you." And I said, "Well, sir, if I was here on my own dime, I'd tell you to fuck off. Okay. But I'm here on somebody else's dime. So I don't want to piss them off and get arrested and waste their plane ticket out here. Okay. So I'm going to do what you say." And so I moved on. But I almost got arrested for reading the United States Constitution. Now, folks, here's the shocker, the revelation out of this. That Constitution doesn't go past the 12th Amendment. I asked Rodney Ross, okay, the head director of the National Military Archives, I said, "How long has the U.S. Constitution been here?" His exact words was, "The United States Constitution has been in the custody of the National Military Archives since 1860. I looked at Lloyd Smith and Kurt Reagan and I go, "Oh my God." You folks know what custody means? Under arrest.
Right.
The Constitution has been under arrest since 1860, and it doesn't go past the 12th Amendment. So what is this Constitution all of you are using, stating that they're violating my rights to equal protection of the law, and I don't have to pay federal income taxes under the 6th Amendment, and I'm a woman, I have a right to vote. No, you don't. I can
Now,
actually prove women don't have a right to vote.
now that's interesting too, because a lot of the times we seek references to obtain full faith and credit. How does full faith and credit apply?
Well, it does and it doesn't.
Hmm.
So what happens is in 1871, the District of Columbia adopted the Constitution. Word for word, sentence for sentence, paragraph for paragraph. It's that Constitution which got all the later amendments. Now, that Constitution, the District of Columbia Constitution of 1871, it's applicable to the citizens, inhabitants, and residents of the District of Columbia and to all the territories and possessions. That's right, folks. Territories and possessions.
Right.
I don't care where you're from. State of Texas is a territory. State of New York is a territory. State of California is a territory. State of Washington is a territory. They illegally flipped us back into a territorial
the
status.
13 unions are the territories?
Yes. Well, they became states at one point. The Queen of England, who owned the Virginia Company, defeated all the states in the original jurisdiction. Okay, and the Virginia Company changed its name to the United States. That's why there's differences of spelling of the United States with the lowercase u and the uppercase u, and most people don't know this.
Yep.
Okay, but the United States is the Virginia Company, which is owned by the Queen of England. The National Forest, look that up. It means the Queen's Forest. So yeah, and every state has a constitution. Like here in Washington, RCW 4.04.010, I believe it is. It says the common law, shall be, the rule of decision. It's also in the CRRLJ 1.1 and CRR 1.1, where the common law shall have an effect in all the decisions of the state of Washington. Every state has a similar statute preserving the common law.
Right.
But it used to say, when you trace it back, it used to say the common law of England. Now it says the common law of the United States.
Now, let me ask you this. Um, when you say that you're authorized under common law like Abraham Lincoln, can you explain exactly what you mean by that in modern court practice?
Well, prior in prior to the 1930s, before law schools spelled with a K, where I guarantee you, if you went to law school, you were schooled, spell with a K, and if you weren't schooled, you were fooled, and if you weren't fooled, you were schooled. They trained attorneys with horse blinders on.
Yep.
Okay, you
Yep.
have to have a license. You
Yep.
have to pay taxes.
Yep.
Okay, and that's all they believe because that's all they were taught. It's kind of like plausible deniability in the Independence Day. Did you ever watch that movie?
No, but I know exactly what you're referencing.
Well, at one point, this guy is asking the president in the movie, "Sir, is it true there's aliens in Area 51?" And the president looks him in the eyes with a straight face, saying, "No, there's no such thing as aliens." And then the guy behind him says, "Well, Mr. President, we have to tell you there really is aliens." He says, "What? I'm the president. You're supposed to tell me everything. Why didn't you tell me?" "Well, sir, we knew that one day this member of the public would ask you that, and we wanted you to be able to look him in the eye with a straight face and honestly tell him there's no such thing as aliens."
Right.
Well, this is how they trained the bar attorney. So the fact of you driving without a license is the same thing as there's no such thing as aliens. That's what it is. And the taxes. They train them with blinders on. And keep this in mind. Every university is absolutely owned and controlled by the Jesuit order. The law schools, they have the Jesuit priest is the provost marshal for every law school in the country except for one. I forget which one it is. And well, the problem is the bar. The bar. Every attorney in the Yellow Pages is a member of the bar. Every prosecutor, every public defender is a member of the bar. And the worst thing about the public defender is they get their paycheck from the prosecuting attorney's office. So do you really think they're going to bite the hand that feeds them? No. Every prosecutor is a member of the bar, and every judge is a member of the bar. So there is a conspiracy going on there, a civil and a criminal conspiracy. They are not part of the state. And the proof the state bar is not part of this state, folks, is that they do not have their main office at the seat of government in your state capital. And there is no elected official who's in charge of it that's accountable to the public. They're a rogue agency that has an illegal monopoly over our courtrooms. Now, one of the things I'm planning on doing as part of my future Operation Greylord CPS groups to take down the CPS, not only am I going to file a writ of quo warranto to dissolve the entire CPS, I'm planning on filing a writ of quo warranto to dissolve all 50 state bar associations, one state at a time.
Okay, now we'll get on to CPS, but I really want you to focus on this question that I just previously asked you. Kind of give us a little bit more definite, if you don't mind. When you're stating that you're authorized under common law like Abraham Lincoln, can you explain exactly what you mean by that in modern court practice?
Yes, under the common law, lawyering was passed down from father to son and father to son. And generally, you had to study the law for at least 14 years before you ever entered a courtroom. Okay. The judge could tell your competency just by reading your legal pleadings, your legal motions. He could tell by your oral arguments that you understood the law. Okay. And then you had the vouch of a couple of lawyers who vouched for you that they mentored you or tutored you. And only the judges have the authority to regulate the practice of law. You can't have the Department of Licensing selling somebody an attorney's license. They're just a dummy at the counter selling a driver's license, a hunting or a fishing license.
Right.
They can't just sell people lawyer licenses. There's really no such thing being sold by the Department of Licensing.
Right.
Now, it's a misnomer too. California actually has a card called an attorney's license. I've seen it before, but I don't think they issue it anymore. But I've seen it, 20 something years ago. It was in their law books in the annotated court rules. It would have an example of what the bar card looked like. Now, for folks, all the dummy sovereign citizens who like to say there's no such thing in an attorney's license, you're not understanding the law. It's a misnomer. Look up the definition of permission and authorization. The subdefinitions of those terms define each other. Okay, so when a judge authorizes you to practice law, When a judge allows somebody to practice law in his or her courtroom, when a judge grants somebody permission to represent somebody else in his or her courtroom, that judge just authorized that person to practice law under the common law rule forever.
Right.
Okay. And that's how it was done prior to the 1930s, before law schools existed.
Now let me ask you this. You did utilize the term sovereign citizen. And you said the dummy sovereign citizen.
There's two different terms of it. There's the term that you and I know that, for example, in the Washington State RCW, there's two different statutes that defines the citizens, we the people, as being the sovereign. We are the sovereign, we the people. And then that congressional record, I read that many years ago, probably, I don't know, 25, 30 years ago. I've seen that before. I'm glad you pulled that up.
Have
We're
to.
supposed to be the sovereign.
Yes. I mean, I have to because every time, we have to get the distinction at least between, what is modern today as far as sovereign citizen is concerned, right? How they have literally flipped its meaning to be a domestic terrorist. But we know within the historical realm of at least what we can see as far as joint resolutions are concerned, is that sovereign citizen was actually something that was desirable, and it was one of the highest statuses that we could receive within our self-governing republic. And so I just want to make sure that you're recognizing that.
No,
And
I totally agree with your
okay,
philosophy and your thought and opinion on that. But folks, you need to realize also the police officers, the county sheriffs, the state patrol, the prosecutors and judges, they have a different definition of sovereign citizen.
now what we
Now,
have been able to do, though, at least with some members here, shout out Acacio, over in New York, we've had it to where there's been claims of, you're a sovereign citizen and we're going to rag on you, right? And then my boy Ocasio came through with this joint resolution, put it on the record, made it an argument, and the judge literally retraced every single step he made, right? Because we were going to bring forth a recusal or disqualification. And so I feel as though if one is able to, again, articulate and in a manner that the judge can recognize, they will take that step back, apologize, or even possibly recuse or disqualify themselves. So I just wanted to make that statement because we have seen it happen. So
yeah, there's what's his name? The guy who runs the no creditors commerce page on Facebook, L something L.
you talking
Uh,
about FL?
yeah. Yusuf L. Somebody posted a motion on his page, and I thought it was a fairly decent explanation of sovereign. You ought to get it from him. That laid out. I think it even cited that act that you posted, and it showed how the attorneys in the courts being unprofessional, violating the rules of professional conduct to libel and slander and defame somebody in
Yeah.
court, and made them correct their behavior with that. But folks, we know that the sovereign citizen, like the act that Cameron just pulled up, shows that sovereign is supposed to be a good thing. But I got to tell you, the city police officers, county sheriffs, state patrol, prosecutors, and judges, they have a different definition. And I agree with it. There's two categories. There's a competent sovereign citizen who knows the law, and then there's the dumbass who thinks he knows the law, who's a fucking know-it-all, who has never seen the inside of a law library, never cracked open a real law book, never taken a paralegal course, has no legal writing skills, has never won a case in any area of law, that misquotes the law totally out of context, even when they get the right case. Most of the time they cite the wrong cases, but even when they get the right case, they misquote it for the wrong purposes. And like, this person is a dummy. They're, in fact, a dumbass,
Yeah.
and they look stupid. And for you folks who want to see this, I've actually collected an email. You're going to love this. I actually got my YouTube channel taken down because I went across every YouTube channel where they were making fun of sovereign citizens. It makes me sad reading all the comments, but I collected all the pages that make fun of sovereign citizens. And you read down the comments, I'm like, it makes me sad because all these bootlickers are saying, yeah, arrest them. These people are scofflaws. They think they're above the law. Why did they put up with this shit? Just bust their window and beat them up and throw them on the ground and tear gas them and mace them. And I'm like, wow, all these slaves,
Yeah.
none of them are
You
standing
know,
up for our
to
rights.
make people aware, not to interrupt, but I'm dealing with a case on someone where he was actually labeled as gang affiliated and arrested and violated on a probation for being a sovereign citizen, but now they're categorizing it as being in a gang.
Yeah, the police officers are the gang.
Yeah, most definitely. Let me ask you this. What is your strongest authority for the proposition that a non-state bar person can function in some representative or quasi-representative capacity today?
Well, this is a big trick. I'm going to reveal to you folks probably the biggest legal secret in the last 150 years.
Okay.
Go read the Sixth Amendment. The Sixth Amendment says you have the right to the assistance of counsel. It doesn't say anything about a right to be represented.
Right.
There's no such thing as a right to be represented. Look up the legal term represent, represented. Then look up the legal term assistance or assistant. So those terms, assistance of counsel, that term, assistance of counsel, is not synonymous with representation of counsel. They're diametrically opposed. They do not mean the same thing.
And I
Okay.
mean, a lot of people are also leaning on the Ninth Amendment in this regard as well.
That's true too. But back to the assistance of counsel, I also want you folks to look to your state constitution, where you have the right to defend in person, and conjunctively all the older constitutions, like here in Washington, it used to be worded in the conjunctive and, not the disjunctive or. Like, do you want an apple and an orange? You have the choice of both. Versus, do you want an apple or orange? That's a disjunctive term. You have the choice of one or the other, but not both. Well, the older Washington State Constitution used to say you have the right to defend in person and have the assistance of counsel. You had the right to both. Now the judges are telling you you can either hire an attorney to represent you, accept a public defender to represent you if you can't afford counsel, or you can defend yourself. Now, this is the big reason why the judges make such a big stink about getting you to waive. You have to agree to waive your rights to assistance of counsel before they will allow you to proceed pro se. It's because of a case called Argersinger versus Hamlin. Argersinger versus Hamlin is a holding case that has never been overturned by the United States Supreme Court. This case says we will not allow you to send a man to the county jail or to prison unless he's represented by a lawyer at trial. That's right. I could rape somebody, beat somebody, and kill somebody. They could find me guilty, but they can't send me to jail unless I was represented by a lawyer at trial. Like, this is the craziest thing you've ever heard somebody say, okay? But it is a fact, and I've actually perfected a method for making this work where if somebody doesn't have the money to hire me for, a big case like an IRS case, I actually kept two defendants about 20-something, 25-something years ago. I had two defendants in Charlotte, North Carolina, United States District Federal Court. They were charged with 6 counts of income tax evasion, 6 counts of willful failure to file federal income tax returns, and 6 counts of a client conspiracy in violation of 18 U.S.C. 371. Okay. These guys didn't want to pay what it would cost for me to beat the case. And I said, well, I can keep you out of jail for, just under 50 grand, even if you're found guilty. And they're like, you can do that? And I said, I could do anything if you pay me right. Okay. So I filed a bunch of documents to keep the prosecutor busy. Discovery, interrogatory questions, request for admissions, and different motions and whatnot. I kept them busy, so they didn't know what I was doing. I kept filing motions for continuance between every hearing. Just short, basically 2 months short of 2 years. They probably had more continuances than anybody else in Carolina. One day, the judge get pissed off and said, "You guys are playing games. I don't believe you're looking for an attorney." Even though between every hearing, we submitted an affidavit showing proof that we had sent out certified letters to at least 3 attorneys every week that we wanted them to represent us. And we even submitted exhibits, letters from attorneys rejecting our case specifically. And we filed that as an offer of proof, number 1, pursuant to evidence rule 103, subsection 2. Offer of proof number 2, pursuant to evidence rule 103, subsection 2, like Johnny Cochran, the offer of proof, the glove doesn't fit, you must acquit. Okay, so I was submitting proof that we were actively and diligently seeking counsel. That way the court couldn't deem that we waived our rights to counsel. So the judge forced these guys to trial. Now, one of the guys got cold feet.
Okay.
And he didn't want to pay me more money. So I made his friend promise him, said, I'm going to drop both you guys. You got to promise me you don't give my paperwork to this other jerk off. And he promised me. So they both show up on the day of their sentencing, scared shitless. They let them both walk. They didn't want to make the attorney look bad because he just hired the attorney. But when it came time about a year later for them to submit their appellate briefs, okay, when the other guy hired an attorney. Well, the rule of law is the court only has to recognize pleadings that are signed and filed by the attorney who's representing you.
Hmm.
Okay. So my paperwork's in play for one guy showing he'd never waived his right to counsel. He didn't go to jail, and the other guy hired an attorney, didn't go to jail that day. But a year later, when it came time for the appeal briefs to be filed, which I never had to file an appeal brief because I already set the record, they couldn't throw him in jail because he never waived his right to counsel. The U.S. Marshals went and picked up the other guy, and he did 5 years in prison because he hired a bar attorney. Versus my guy who followed my instructions, never spent a day in jail.
Now, what's crazy, we actually have Joe. Oh man, I think he's Virginia, if I'm not mistaken. And yeah, he went just to help his son, kind of make sure that he was on point. Never crossed the threshold. And Joe ended up spending, I think, about 30 days in jail. Not speaking, not representing whatsoever, just was being an assistance of counsel to his son. Joe got out of jail, and it was a wild situation too because Joe ended up having pretty much all of the district of judges recused from that case, and then ended up going to trial where they ended up finding that he wasn't doing any kind of what's it called when you're representation of law, UPL, right? And had a complete UPL charges, brought forth against him. It was completely found not guilty, and he's got a big one because he spent quite a long time in jail, and they violated him pretty heavily. And I'm pretty sure that he's going to be moving forward with a suit here soon, fairly soon. But yeah, man, we've had people where they're getting arrested for UPL, coming right out of it, having all of the judges literally disqualified, and then coming through and winning on trial as well. And yeah, he stood on it pretty heavily and won in trial. So let me see.
I've done extensive briefing on unauthorized practice of law.
Mhm.
And, so if somebody wants to hire me for that, I can beat those charges, but, it's not cheap. And I'm not going to help somebody who's a goofball who wants to practice law. I'll beat the criminal charges, but they can't go in the court and try to represent people if they're not competent.
Right.
But I've drafted briefings proving that the State Bar Act here in Washington, I know the same as everywhere else, that the unauthorized practice of law statute only applies to current members of the bar, former members of the bar whose dues have elapsed or expired, or somebody who was previously suspended or revoked from practicing law. But it does not apply to somebody who is not now and has never been um, authorized to practice law. Now, not every state's the same, though. They're similar, but they're not the same.
Right.
Yo, what's up with the 12 presumptions of law that apparently all like bar members silently acquiesce to?
There's also the 7 Ashwander rules that goes with that.
Like, did you know, right? The guy that's on the presentation right now? Because
Like
you
one form, like an example, one form of the 12 forms of presumption is silence, which is acquiescence, which is a form of consent.
Well,
Yeah, but I was like more specifically like the first one is like all court proceedings are actually bar proceedings, and the second one's like um they're not actually legal proceedings, but they're simulating a legal proceeding, and then like the third one is like um the defendant or client is assumed guilty, like stuff right, Mr. Bar person, Mr.
well, I actually let my dues expire recently
Lewis.
because I got tired of people accusing me of being in on the conspiracy to screw you over. Let me tell you something. The attorney under corpus juris, their first duty is to the state, their second duty is to the court, and you come last. With me, my first duty to whoever's paying me, I say fuck the state, fuck the court. My duty's to you if you're the guy that's paying me. You know, I can't guarantee wins. Guaranteeing a win in court is against the law. No attorney will guarantee, and neither will I. The only thing I'll guarantee you is I'll get your money first before I do any work for you.
My God.
You are a firm ass on that.
Yeah, I'm just tired of all the
I
I'm
do
just tired
gotta,
of all the freeloaders.
How do we actually identify a judge acting out of capacity or practicing law from the bench,
Well,
or acting
I,
prejudicially, or
I I run into some of that kind of problem where, Your Honor, I object that you're making the argument for the prosecutor because the prosecutor is not competent to argue with me. And the fact is, the case law in Washington State under the separation of powers doctrine says while you can wear two hats, so to speak, you can't wear both hats at the same time. So if the prosecutor is not competent to argue this case, I request that you recuse yourself, that you take his place and bring another judge in here to adjudicate this matter. And I'd be happy to debate with you if you act in the capacity of a prosecutor, but not while you're sitting on a bench.
so exactly how would someone identify that in court, especially someone who's not well versed or aware? How could they
Because
have like an easy
they try to
example?
enter facts. They try to enter facts. That's the first clue. They try to say, well, you are this. Don't you live in this place? That's entering a fact.
So
Just so
that would
they
be
ask you a question.
prejudicial.
Okay,
By
now
asking you questions.
entering a fact and people want to put things into evidence. Most people are unaware of this, but there's two court files. There's the motion file where motions can be denied all day long. And then there's the evidence file. Most people think all my evidence is in the record. I said, no, it's not. You filed white paper. You filed white paper with no ink on it. It's in the motion file, I guarantee you. Okay. Most people don't follow the court rules. So I tell everybody the first thing, if you're going to go into this court system, you need to buy a set of the state court rules from Westlaw or LexisNexis. And then you also need to go to your county government website and download and print out a copy of the local court rules. But let me tell you something about this. People go into court saying, Your Honor, is this common law, jurisdiction, or equity, and all that other nonsense? And let me tell you
That's how
something,
you
folks.
get annihilated.
Yeah. Instead, I want you folks to look this up for Washington State, and every state has a similar case. The city of Seattle versus Filson, FILS1, the city of Seattle versus Filson. That case will tell you the courts of limited jurisdiction only have the authority or jurisdiction conferred by a statute. Now, in Washington State, the municipal courts are created and established by RCW 3.50. The district courts are created by 3.66. The state superior courts in Washington and the state Supreme Court in Washington are created by RCW 2.0. Okay, so the courts of limited jurisdiction only have the jurisdiction conferred by a statute for misdemeanors, civil infractions, and gross misdemeanors. They cannot adjudicate and hear a felony crime. Only the state superior courts, the appellate courts, a court of general jurisdiction, a court of record, or the state Supreme Court can hear and adjudicate a felony crime. So, in other words, for a court to have jurisdiction, there has to be a statute. Running a red light, speeding, driving while suspended. Now, you folks are going to love this, but if you ever got a ticket because a cop ran a license plate check, put in a demand for discovery to the prosecutor saying, I want a copy of the statute. I want the session law, the Senate bill, and the House bill for a statute that shows the cops have authority granted by the legislature to run a random roving warrantless license plate check.
Thank
I
you.
even I even have a flyer that destroys that on the spot where the cop just says, well, I ran your license plate. Oh, here's my flyer showing you can't run a random roving license plate, a warrantless license plate check. Can't do it. Not illegal. I mean, it's illegal. They can't do it. Okay. And a lot of times they use that for pretextual stops. Probably the most famous case in Washington for pretextual stops is a case called State versus Ladson. A pair of black guys.
We use
were
that a
caught.
lot. Just we use that a lot, actually, or at least I know I do. So go ahead.
Right. Okay. So a pair of black guys got spotted by some racist bigot white boys driving around to the city of Lacey. Oh, look at these homies. What are they doing here? And the cops were jealous because they had a nicer car than they did. So these guys pulled into an AM/PM, buy some snackies. They get back in their car. The minute their car exits the parking lot, woo, the lights come on. You're under arrest. And of course, like Patrick Knowles versus Iowa, which is the number one U.S. Supreme Court decision for pretextual stop. So of course they find a gun, marijuana, and money in the glove box. Well, citing Article 1, Section 7 of our state constitution, which is worded more stronger than the Fourth Amendment regarding the right to be not to be searched without a warrant. Well, our state constitution is worded differently than the Fourth Amendment, worded more strongly. Okay, so according to the gun wall standards, look that up, folks, state versus gun wall, where they make a comparison of the federal constitution to the U.S. Constitution. So when you make when you write up your motion showing this section of the Constitution is being worded different than the federal Constitution, and you show how it meets all the factors, Article 1, Section 7 uses the term, quote, without authority of law. That means there has to be a statute granting them jurisdiction to do whatever it is they're doing. Okay, so they ruled it was a violation of Article 1, Section 7 of the Washington State Constitution without authority of law clause. And so the cops ran a random roving warrantless license plate check. Now, think about this. How did they know their tabs were expired? Because in Washington State, like a lot of states, the tabs are color coded by the month.
Right.
Okay, so they were still within the grace period. Some people don't realize that this month their tabs expired, so they got a grace period to the end of the month. They're not supposed to pull you over. Okay. The color code changes next month. So if you get caught with your tabs expired because you're expired by the color code, you should know that your tabs are expired because it tells you every time you walk up to your car. If you're coming up from the behind, if you only have a rear license plate, and some people have the plate on the front and back, but the tabs are only on the back, you should know your tabs are expired. You need to go in and renew them. Well, it's nighttime, which also violates a statute in Washington. I think it's 4664-070. Only officers of the State Patrol during daylight hours may run a check. And if there's like a tail light out, a headlight out, and you don't know it because it just went out, they're supposed to give you a 10-day warning ticket before they give you a ticket. And I've gotten a lot of tickets dismissed on that because they didn't follow procedure.
Yep.
I'm sorry. It makes me think in Florida, there's a statute that I try to argue that it's like Florida Stat 316, I think 507 or 9 or something, but it's about turning on the red and blue lights that requires an emergency in order to do so when it requires two elements, and those two elements procedurally would be an injured party or damage to property. And when those two things aren't existent, then that means that there is no emergency, kind of violating the statute from the moment of the pullover to begin with.
And I haven't seen anybody win a case on that argument yet. Okay, the sovereigns and the so-called state nationals out there, they're painting a huge, gigantic paintbrush.
It's ideological and
it's too generalized, and the law is very specific. Under the law of general statutes and special statutes, or what they call specific statutes. Okay, when there's two or more statutes regarding the same subject matter, the specific statute supersedes the general statute.
Right.
Okay,
and even more so is using the whole act rule when you're going all the way back to the intention of the legislature and its creation in the first place. Even if there's been amendments or changes throughout all of the years, it's going back to the original in and of itself. But most people don't know how to invoke that doctrine to be able to say what was the intent of the original creation of the statute in the first place.
I think that's why it's most importantly not necessarily attacked to the statutes, but more so the procedures and also the courtroom rules and everything their rules that they are supposed to follow, because there's always the hole in that versus what actually happened in the case. I mean, would you agree with that, Lewis? That it's more always to attack rules?
Pretty much. My method is show them the mirror. If you're going to charge me of violating a statute,
I said that yesterday.
I'm going to say, let me see that statute, because I'm going to read that statute, and then I'm going to go research the annotated case law where a judge in another court, maybe the same state, a higher court in the same state, higher courts in other states. I'm going to see how the judges interpret that statute.
Yep.
It's not just my opinion versus your opinion, but now I write a motion citing case after case after case, which we call the doctrine of stare decisis,
yep,
of settled law, where I show the cop, you've misapplied the statute as applied to me, or you've charged me with the wrong statute altogether. Yep. Sun Tzu, The Art of War. Know your enemy better than he knows himself. This is why I have been called the Code Buster here in Washington State, the RCW Code Buster. That's my email address, RCW, which stands for Revised Code of Washington, RCW Code Buster at AOL.com, Yahoo.com, Gmail.com, and ProtonMail.com.
And
Okay.
I might have to take the National Code Buster Gmail then. I don't know.
I'm gonna type this in. Could you
Well,
repeat that again, please, Lewis?
RCW Code Buster at AOL.com, RCW Code Buster at Yahoo.com, RCW Code Buster at Gmail.com, and RCW Code Buster at ProtonMail.com.
Now let me
My
ask
home
you
phone,
something. Oh, go ahead.
my home office phone, area code 360-335-1322. That's 360-335-1322. My cell phone, area code 253-226.
Hold on, Lewis. You had broken up.
Sure. My cellular phone for text messages is area code 253-226-3741. I live in Washington State in Grays Harbor County in the city of Mo Cliffs. I live on a cliff overlooking the water. I'm 10 minutes south of the Quinault Indian Reservation. I'm 35 minutes north of Ocean Shores, and I'm about 45 minutes west of the city of Aberdeen, which is approximately 45 minutes to an hour west of Olympia on Highway 101. But I'm out here on the coast.
Now, what
I'm
I
looking
want,
at I'm
go ahead.
looking at the ocean right now, you know. But I'm not rich. I'm just a renter. But you know, I have first dibs to buy this house when my landlady decides to sell this house.
Okay. Now, in relation to the CPS and family court questions, um, you've emphasized that you do like CPS defense and that you fight CPS aggressively. What are the most common due process violations you see in CPS cases?
Number one, and this is going to be part of my Lewis Ewing Operation Grey Lord CPS groups, which the name of the project has attempted to be stolen by a dizzy broad. I won't name her name on here because she's not even worth mentioning. She's a brainless bimbo who's never won a legal case. She's never won a CPS case, never caused a single child to be returned home. She was on your show last week. I won't mention her name just because you asked me not to. Um, but anyway, the number one due process violation that shows a conspiracy, which is going to be part of my writ of quo warranto, is the Bar Association, the bar attorneys conspired to put the entire family code on the civil side of the court. Now, everybody complains there's no jury trial, and why don't we just put a bill before the legislature to make it require a jury trial? And I said, you can't. And they're going to say, why not? I said, because there's already a family code. Most people don't know this, but the family code, they put a statute in the back of the chapter somewhere that says there shall be no jury trial in the family court. Now, here's the big due process violation. You go, folks are going to love this. It's a combination of two things: the preponderance of evidence and Briscoe versus LaHue, a holding U.S. Supreme Court decision that first granted authorization to police officers to get away with committing perjury in open court. That's right. Police officers were granted absolute immunity for committing perjury in open court in a U.S. Supreme Court decision called Briscoe versus LaHue. I first mentioned this at a large patriot meeting at the Freedom Hall in Oklahoma, where Dan Metter, a famous tax patriot, at that time was considered one of the top IRS tax gurus in the United States. Dan Metter purchased an old elementary school building, and he called it the Freedom Hall in Oklahoma. And I first announced to a crowd of over 200 patriots about Briscoe versus LaHue. This is 1999. People today, they're just as lost, if not more lost than then. I haven't seen the family law groups move anywhere since 1999. But the preponderance of evidence, you folks Google on Westlaw, I forget which one it's sold on, Westlaw or LexisNexis, purchase a set of books called McCormick's on Evidence. McCormick's on Evidence says the preponderance of evidence standard is the lowest threshold of evidence there is based upon the weight of a feather at 51%. This is why your volume went off, Cameron.
That's very true. And the preponderance level is just a tipping of the scale. In other words, right? It don't have to, yeah, it's just the tipping of the scale. And it could be very minute. So yeah, continue.
Okay, so I also done some a shepherdization of Briscoe versus you, and I found the family law cases, the CPS cases. Oh my God, you won't believe what it says. The immunity that was first granted to police officers for being able to commit perjury and not be charged with perjury, that was first extended to police officers in Briscoe versus Hugh, has now been extended to CPS social workers, guardian ad litems, public defenders, the assistant attorney generals, the county prosecutors, and even to the family court judges themselves. Wow. Okay, so this is how the social workers are getting away with going into court, presenting nothing more than hearsay testimony, might all be a lie, and the judges rubber stamping, stamp, 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 50 to 100 emergency pickup orders. And so now the county sheriffs, the CPS social workers come to the door, knocking on the door with the county sheriff in tow behind. So the parent opens up the door and says, I'm CPS. We're here to do a welfare inspection. However nice they say it. Because they'll listen. They will pretend to be nice to you, but they're the witch in the gingerbread house. Okay, so I first drafted a flyer. CPS cannot search your house without a warrant flyer in 1999. And in the year 2000, I wrote another flyer called 18 U.S.C. 5033, Invoke Your Child's Right to Remain Silent flyer. Now, some of my detractors or haters will say, oh, Mr. Ewing's giving wrong advice. That's for criminal only. And I tell everybody, don't listen to these motherfuckers. They're just jealous, that I have more legal knowledge than they do. I said, guess what? When they come into your house to do that so-called civil administrative search under camera versus municipal court, look that up, folks. That's the number one case for civil administrative search, camera versus municipal court. The city of Seattle versus Barlow. City of Seattle versus C versus the city of Seattle, and another case called Marshalls versus Barlow. Those are the top three cases for civil administrative searches. Well, why are they looking in your underwear drawer? Okay, what kind of civil search is that? They're looking for a meth pipe. They're looking for a crack pipe. They're looking for a marijuana bong in your closet. The minute they find any kind of drug paraphernalia, that so-called civil administrative search has now turned into a full-blown criminal investigation where you could be charged with negligence or abuse. So now they're telling the parents, you need to bring your child outside. We need to talk to your child out of your presence. Well, that violates 18 U.S.C. 5033. And you folks are going to love this, but in 1999, 2000, there was a case in San Francisco that was held by the Ninth Circuit. And this case was all over the radio and newspapers. CPS had come to the door with some rich Mexicans, and they found a meth pipe in the house. So they seized their kids. They interrogated the kids out of the parents' presence and found out more about their drug use and drug paraphernalia. This was all over the radio, television, and newspaper. And the Ninth Circuit was having a hearing. So I called up a process server out there in San Francisco in the Ninth Circuit, and they said, we're booked. We don't have any time. And I said, well, how much extra would I have to pay you to do it? This is an emergency. They said they wanted another $600 on top of their normal fee. I'll pay it. Okay, so they get to the courthouse first thing in the morning, and they put me on the phone with the court clerk. She wanted to know who I was and why I wanted it. I said, I'm a federal bar lawyer. Here's my bar number. I'm also a tribal lawyer. And to throw the court clerk off track, because this is a hot case, I said, I need to use this. I have a case right now in the tribal court, for Indian children. So that made her happy. It appeased them because the judges didn't want this case getting out. Okay.
Oh, I'm
So he
fighting a
buried.
lot of this in tribal court right now. So yeah, this is good.
So I'm very familiar with ICWA. Okay. I know a lot about tribal law. And so anyway, the guy was approved to make copies of it. And right around lunchtime, he called me up and he said he was just loading the file in the trunk. And he says the bailiff and the court clerk are running down the steps. He barely made it across the street because traffic was so busy and they were screaming at him to stop. I said, ignore them, jump in your car and drive away. Not even 5-10 minutes later, it was announced in the newspaper that the court ruled in favor of the parents, and they ordered that case to be unpublished and sealed. I go, oh my God, I struck gold. So I wrote my 18 U.S.C. 5033 invoke your child's right to remain silent flyer after I read through all the files. It was about 9 inches of shit that I had to read through, and I narrowed it down to the top 3 cases. And so I put those top 3 cases in my flyer. And I've had parents. I tell them when the cops come to the door, you hand them immediately. You step outside, lock the door behind you. You hand them my CPS cannot search your house without a warrant flyer and my 18 U.S.C. 5033 invoke your child's right to remain silent flyer.
Where do we get these flyers?
Right.
You send them to my email, RCW Codebuster at AOL.com, Yahoo.com, Gmail.com, and ProtonMail.com.
Now listen, I also just make sure y'all are paying attention in the chat right now as well. Lewis sent me a whole bunch of his flyers, and they have all been translated over into this Google Drive link, which you can find as well. Okay.
Okay. I keep this in my car. Okay. This is what I call my travel pack. I even have a cartoon, which I need to get a copy scanned. You see the picture of Nazi Germany
Yep.
cop, the Russian cop, and the American cop. Let's see, the Nazi German cop says, "You will be free to go as soon as I see if your papers are in order." Nazi Germany. Communist Soviet Union. "You will be free to go as soon as I see your travel permit." The American cop. "You will be free to go as soon as I see your driver's license, registration, and proof of insurance."
Right.
The old highwayman. I got the wagon and the stagecoach, right?
Yep.
You could travel down this road if you pay a toll tax.
Yeah. Oh.
The new highwayman. I hand these out everywhere I go. The new highwayman. "Sir, you can be on your way if you mail in your fine, pay your license fee, insurance fee, and provide proof of your emissions test. Oh, and make sure you buckle that seatbelt."
Yeah.
Okay. Now, one of the most important flyers here in Washington, we're back to the right to travel issue because that's what most people are here for. We can go do CPS and special.
Yeah.
We can go back and forth however you want.
We're all no, seriously. You got family, you got CPS, you got right to travel. You got, I mean, everything is here, bro. It's not just right.
I think it's all under the same umbrella, isn't it?
Okay, folks, let me tell you something. You're talking to a man who's beat the IRS. You're talking to a man who's beaten the SEC in major security violation cases. I've beaten CPS. I've caused dozens of children to be returned home. I've caused dozens of children not to be even taken in the first place. And you know, what's the best thing? What's better than beating a case? It's stopping a case from even happening in the first place. My CPS cannot search your house without a warrant flyer in combination with my 18 U.S.C. 5033 invoke your child's right to remain silent flyer has caused more children to be returned home and not taken than every other leader, so-called leader in the family law movement, which I think are a bunch of scammers.
Okay,
You know,
hold on. All right, keep it light. You're good. Just keep yourself right. You're good.
okay. Also,
Wait. Beyond flyers. Okay. What documents, records, affidavits, timelines, and objections should parents preserve immediately when CPS gets involved?
first thing you should do is 2 things: a discovery motion directly into the court, and also a state law public disclosure request under your state public disclosure law to the administrative agency itself. Because sometimes when you ask for discovery, they don't give you everything that's in possession of the CPS office.
Right.
They try to pretend like that's a separate file. Oh, you didn't ask for this.
Right.
Okay. So you don't know all their underlying notes and stuff. Now, the cool thing about the state public disclosure law, most state public disclosure laws require they provide a response within 10 days, or they have to send you a letter stating they need more time to prepare the response. And then in like here in Washington, you can hit them for like up to $100 a day for each document that they don't provide. Now, you cannot use the state public disclosure law to ask discovery questions. You have to ask for specific documents. Okay, you have to name the documents because they're not going to do your research for you. But that is very important. So you want to get copies of the police officer's narrative report. So I also recommend going directly to the police department. Sure, you're going to file your discovery motion directly into the court, but you also want to go to the city police officer's office, the county sheriff's office, go to the counter and say, "Sir, I'd like to speak to your public disclosure request officer." They might say, "Well, what do you want?" Because that's probably the person who it is. They say, "Well, I want a copy of the police narrative report. They're going to say, oh, well, you need to ask your attorney. You just tell them, no, I'm representing myself. I'm my own attorney. I'm going pro se and I have a right to a copy of my own discovery. So let me have your public disclosure request form and I'll fill it out. So you fill it out and get a copy of the police officer's narrative report. That's very important in traffic stops too.
Yep.
Okay. Most people don't realize this, but the cop filled out that ticket. At the bottom, he signed it. I certify and declare under the penalties of perjury all the above in my report on the back of this is correct and true. Well, most of you never put in a public disclosure request for a copy of that report. In the old days, you would sign it, they would tear it off, the carbon copy, and give you a carbon copy form. Well, turn the back over, there's no report there.
Right.
That's incomplete process.
Right.
Look at court rules 2, 3, 4, and 5. To be complete process, they're supposed to give you the summons and the complaint together. A cop giving you a traffic ticket is defective process, and I used to beat a lot of tickets on that in the old days. Okay, they actually got rid of the carbon copy form because of me. They used to get rid of the signature. They used to have your signature because I had put out information everywhere about a case called Port Orchard versus Tilton. Okay, where they have to get your signature. And if you refuse to sign a ticket, they couldn't take you to jail for just refusing to sign a ticket because you're refusing to sign a contract. Okay, they can't force you to sign a contract.
Oh, they can. They'll take you to jail for it.
No, in Washington, we have
they call it what they call it, instanter.
Well, guess what?
Instanter.
I have a statute, an RCW statute. I don't remember it off the top of my head, but in Washington State, there's a statute called obtaining a signature under duress as a Class C felony.
Yeah. Well, I guess I've been working with my boy Dan on this, and it's pretty funny because it was down in Texas, and yeah, they told him if he don't sign, they're taking him to jail. He said, "I'm not signing it, y'all," and he said, "All right, we're gonna arrest you right now, and we're gonna utilize the instanter clause." Okay, or rule, right? Which doesn't even apply whatsoever for them to actually do what they did. And it's very interesting because he's getting ready to bring forth a complaint on that one as well because everything was dismissed, of course, that they took him to jail just because he didn't sign. But just to backdoor that or just second that, what about the right of rescission for the 3-day rule when people start writing on top of the ticket and they send it back in? I've never seen it work. What is your stance on that?
I have seen it work a few times, but only for civil infractions.
Okay. I've never seen it work.
It won't work on a criminal offense. You might get lucky. Here's what happens, because I've seen people make arguments and they claim it knows it works. The sovereign will go in the courtroom. The whole courtroom is full of people, especially like in Portland, Oregon. Oh my God, it's horrible in Portland, Oregon. People are waiting outside a block, 2 blocks down in line waiting to pay their tickets.
Right.
Okay. So here's the scenario. Somebody goes into court and they call their name first and the judge dismisses the case. The sovereign's got 2, 3 people with him. He's all excited. It worked. It worked. They're scared of my paperwork. And so they go off on the internet and say, I'm the new guru. Buy my kit. Buy my package. Attend my Zoom meeting and make a donation. I'll lead the way, And here's the truth of the matter. I've seen this happen. I'd be sitting in the front somewhere and I would see the prosecutor, go up to a sidebar. Okay. And I could literally, I was reading their lips and I could just barely hear what they're saying. And the prosecutor's saying, look, we got one of these dumbasses in the courtroom. Okay. And did you see the stack of junk that he filed? We got a courtroom full of people that just want to pay their ticket. This is going to cost us to lose $5,000, $10,000. And the judge said, well, what's he in here for? It's only speeding. It's running a red light. We can't give him any jail time anyway. Let's just get rid of him. We'll get him on another day when we can nail him with a criminal charge and give him some jail time, teach him a lesson. And so when they call his name, they dismiss it. Not because your paperwork or argument had any legal merit to it. They dismissed it because they had a courtroom full of people that wanted to pay their tickets and they didn't want to lose any money, wasting their time arguing with some fucking moron that doesn't know jack shit about law. That's what I call the dumb fuck sovereign citizen. Okay?
Yep. All right, back to CPS. What role do federal claims play in CPS matters? Due process, equal protection, Fourth Amendment home entry issues, retaliation, Monell type theories, or other civil rights claims.
Well, one of the things I'll be doing.
Could I also add to that, if you guys don't mind? if CPS isn't involved in, like, let's say, like for my situation, ex parte removal of children, though CPS isn't involved, how to go about that as well, to add on to what Cameron just asked.
Okay, the first thing you need to do when you got any kind of a case is go down to the court, get a certified copy of the court docket, and ask the court clerk to put the seal of the court on it. Also get a certified copy of the entire court file and ask the court clerk to put the seal of the court on it. And there's a couple of reasons for that. You want to preserve the record. Okay. Number two, you want to prevent fraud by the prosecutors and assistant attorney generals, because a lot of these statutes require a 10-day proof of service, a 14-day proof of service, or a 20-day proof of service, depending what kind of action they're bringing against you. Same thing with a foreclosure on a house, and I've dealt with foreclosures before. I've stopped foreclosure proceedings here in Washington. I'm one of less than two people. Only one other person I know has beat Perkins and Coie and RCO Legal, and that was a man named Kurt Riggin. He lives in Colorado. He used to live here in Washington.
Now you said you've been doing a lot of this. You've been in the movement at least since what, 1999, a little bit before.
I started where like all you guys are at, 1985. I'm in the old days they would call people like me a constitutionalist. That's somebody who really studies the law.
Yeah.
Okay.
Well, if you the cops nowadays, bro, they're literally like you're one of those constitutionalists, which then they refer it back to sovereign citizen.
Well,
It's
that's
so
more of a
bad,
compliment.
man.
A constitutionalist is kind of on a higher level because they
Yeah.
realize that you know some law.
Yeah, but they
Sovereign
reference it.
citizen is down here, who's
but
the
there's
dumb fuck.
I know, but what they're doing is they're referencing you're a constitutionalist as a sovereign citizen now. That's how bad the cops are.
Well, I'm the last of the generation that reads books. Okay, you see this stack of books behind me, the stack of bookshelves?
Yeah.
Okay. Every single one of those 3-ring binders, I filled by hand with case law like this. Okay?
Oh yeah, no, bro. We read heavily, right?
Well,
a lot of the videos is verbatim.
What I'm telling you is every single one of those 3-ring binders I filled by hand, one page at a time, copying case law.
Good.
I've got over 300 in here. This is just in the last 12 years. I have over 300 3-ring binders.
Beautiful.
That I filled by hand, copying one page at a time. So I read the cases, I highlight the cases, the important case quotes in the case. I take a 3-hole puncher. You know, these I haven't put in the notebook yet. Obviously, there's no 3 holes in them. But when I'm done, I take a 3-hole puncher and punch the 3 holes in it, and then I put them each in a different notebook by category. I don't know how much I can move this camera around, but you can see some of the bookshelves. I've got a stack of paperwork next to my computer and printer. There's a $4,000 printer, a bunch of notebooks over there. I don't know how much you can see on that. But I also have a storage locker in Eastern Washington, which I have probably. Do I have the camera good? Can I put the camera back?
Yeah, you're good.
So I have a storage locker in Eastern Washington with like, I don't know, 25, 26, maybe 27, 6-foot high, five shelf bookshelves over the last 30, 35 years that I have over 3,000 3-ring binders where I photocopy case law by hand, one page at a time at the law library. You will not find an attorney or a lawyer anywhere in the state of Washington or probably anywhere else that has photocopied and read more case law than I have.
Okay, back to CPS again. When does CPS case become a federal civil rights matter? And when is federal court likely to abstain or decline involvement because of ongoing state proceedings?
They generally don't want to get involved in the state courts till the state case has run its course, until you've exhausted all your administrative remedies at the state level first. But if you want to bring in federal violations, and this is going to be part of my Operation Graylord program, where this is stuff is not revealing to the public because there's scammers out there that want to steal my idea and make money off of it, but they're not competent to do this. But I will be putting in demand for discovery for copies of all their financial records, all the sources of federal funding. Everybody talks about Title 4D, Title 4E. Everybody knows that stuff, but they don't know what to do with it.
Right.
Okay. So what I'll be doing is I'll be asking state law public disclosure request directly to the CPS office in your county.
Okay.
I'll file a second state law public disclosure request to the main CPS office in your state capital. Separate from that, I will be sending a FOIA, a Freedom of Information Act request under 5 U.S.C. 552, 5 U.S.C. 552A, and the 1974 Privacy Act to the Secretary in Washington, D.C. And what I've discovered is a lot of the states are engaged in what's called double dipping.
Right.
Okay. That becomes a federal offense. Okay. Violation of the electronic mail fraud statute.
Mm.
Okay. When they send a demand to the father or the mother, they got a child in custody and they're demanding child support, they send that letter in the mail. They demand payment of money under the threat of arrest for contempt of court for refusal or neglect to pay child support. So that becomes a violation of the Hobbs Act. An
What is
economic
that
crime.
citation?
What's that? The mail fraud statute, I believe, if I remember correctly, 18 U.S.C. 1343, I believe. Well, I got so many statutes in my head, I can't keep track of all of them.
Yeah, I think that's right. And then Hobbs Act is 18 U.S.C. 1951.
Yes. Yes. Okay, so the Hobbs Act is a combination of an economic crime with the use of force or the threat of the use of force. Then the dummies will say, well, you have to pay child support. How is that a violation of the Hobbs Act? Well, if you can prove that they committed perjury, submitted documents to contain materially false statements with intent to mislead the trier of fact to make a ruling one way or the other, or if they committed perjury in open court, and then they put that in writing, and they send it through the mail, and you can prove that it's false or forgery or perjury, and they send it through the mail, it now becomes a violation of the Hobbs Act.
So is it a violation like in family court where they think proper service is done only through email?
Anything that's on the internet, if it contains evidence of a crime, could be a violation of the electronic mail fraud statute. And then there's also the mail fraud statute for hard paper, physical mail. The mail fraud statute also could have effect if they're sending documents in the mail through the post office. But it's very important that you get certified copy. Go back to the thing I said, sir, you want to get a certified copy of the docket with the seal of the court on it and a certified copy of the court file of every document. Now, the docket will list the name of the judge, name of the public defender, the assistant attorney general, the names of the social workers, names of the guardian ad litem, and have your name, public defender's name, or your for hire attorney's name. It will list the name of every document that was filed and the date that was filed. Now, the reason why I say it's important to get these documents certified with the seal of the court attached, sometimes some of these statutes have a proof of service requirement. So what happens is, if you didn't get a certified copy of that document and they realize somebody smart looking at the file, the assistant attorney general or the county prosecutor go, oh shit, we forgot to file a proof of service, or we never did. So they will falsify, they will forge a document, and they'll go into the court clerk's office and they'll check out the file for a minute, and they'll slip something into the file after the fact. I've stopped foreclosures based upon this kind of crap.
Okay. I want to move into jurisdiction for a sec. I want to see your thoughts on this as well. When you hear someone say that the court has no jurisdiction, what do you want them to understand before they make that argument?
They're throwing out big words they don't understand.
This is a beautiful one.
You have no jurisdiction, Your Honor. I'm the living, breathing man. You might as well sing the Aretha Franklin song. I'm a beautiful woman. Okay. I'm sorry, but these guys are making crackpot arguments because they're just too lazy to study the law themselves. I tell everybody, stop listening to the gurus on the internet. In fact, here's how you can tell the difference between a competent legal speaker versus an incompetent legal speaker. Okay, a competent legal speaker will cite his or her authorities, the statute, the court rule, the case law.
Nope.
so that you can go to the law library and look it up. Now, the dummy sovereign citizen will say, well, statutes aren't law, court rules aren't law, case law is not law. I know more than the judge because I'm the all-knowing, almighty. Shut up. You're not the Wizard of Oz. Okay, you're
Or
the
they'll
little
take
behind
a
the
case
curtain that
law
doesn't
that
know
doesn't
shit.
even
Okay.
apply to it, or was just something that was said during a hearing in a transcript, and then call
Well,
it case
well, it's
construed do
it's
that.
it, well, it's stare decisis. That's number one. Number
The
two
doctrine of
is
stare
that
decisis, yes.
number two, literally whatever you want to utilize to support your argument and belief or stance, I promise you can be found in case law or opinion. I promise you. You're just not looking hard enough.
Everyone looks at mainstream and commercial sources as the issue. They don't look for what's suppressed.
Yeah, here's a funny thing, Cameron. The sovereigns, they get mad at me for putting them down, so to speak. And they go, well, Mr. Ewing's the statutory guru. I know the common law. And I go, oh, really? I'm going to prove to you folks I know the common law better than these so-called common law gurus and the so-called state national idiots.
But wait a
Which to
second,
me,
Lewis. But wait a second. Common law is statutes. Some statutes are common law. Let's
yes.
get it right. Let's really understand it for what it is.
I have a
There is
dissertation on the stare decisis
Is
that I'll
this
email you.
bias, Lewis?
Anybody who sends me an email, I'll send you a dissertation of the doctrine of stare decisis that you could actually put at the end of any of your legal briefs to show the judge, look, I said in this case, and you put my small section on the doctrine of stare decisis at the end of your case, your judge will be hard pressed to deny your motion with this stuff put right before your conclusion, asking for the dismissal. I got the perfect case law on the doctrine of stare decisis for Washington and many other states. You will absolutely love it. But let me tell you something. Let me tell you one more thing, Cameron. I know you're anxious.
No, you're
I
good.
do talk. I do talk.
No, you're
Okay.
good.
I'm a talker. Okay. I'm used to teaching an 8-hour seminar. Okay. I can talk with no preparation, no script. I can go into any area of law and just talk. Okay.
Yeah.
So here's what I'm going to say. The sovereign who's trying to contradict me and say Mr. Ewing's the statutory guru, and that's nonsense. Statutes and court rules and case law aren't the law. I know the common law. I go, really? Well, I'm going to cite a famous common law case called Hurtado versus California. Never been overturned.
Right.
This case cites a case from the 1700s, citing a case. Yeah, it's a case from the 1800s, citing a case from the 1700s. It cites a case called Entick versus Carrington. If it's the law, it will be found in our law books. If it's not the law, it won't be found in our law books. So these guys who claim they're the common law guru, I say you're full of shit. I want to see a statute, a court rule, a section of a constitution, the Declaration of Independence, the Magna Carta section, the Treaty of Guadalupe section, an Indian treaty. I want to see case law that supports your argument. And they can't come up with shit because they're trying to baffle you with their bullshit. But come to the next lesson and donate more money. Come to the next county council meeting and donate more money. These people are scammers. Do not take legal advice from somebody who's never won a case. You need to stop all these people from talking and say, hey, that sounds good, but I want you to give us a case number showing proof that you've ever won a case making this argument. And they will block you from their group.
Listen,
It's
bro,
all
you know
about
what's
procedure and courtroom rules. Hold them against their own accountabilities and their own rules.
amazing about just Operation Wisedome is the fact that we've really encompassed what it takes for each and every one of us to utilize each other to be able to accomplish the task at hand, whatever it may be, or the challenge. And I think that's what's beautiful is that I am not a guru, right? I guess I don't know. I'm just a part of the Wisedome.
Right.
And
Yeah. Well, I mean, we
Bro,
put this
I
together
actually
so
like
we
that
can
name.
understand that, right,
I'm the
Cameron?
what
Wise
do you
Dome. I
mean?
like
no, but
that.
okay, well, wait. Here we go. We're gonna hit him.
Cameron is
The Wise Dome. I love it.
fire,
Give him the
bro.
Wisedome, bro.
We're gonna hit him.
Always
We're gonna
showing
hit him
proof.
with it though. Watch it. This is the question, Louis. What's your definition of a mastermind?
Definition of a what?
A mastermind.
Myself.
This guy. Okay, good. No, seriously. What is your definition of a mastermind?
Somebody who
Nope.
has
Stop. You're done. You're cooked.
I'm
Hey,
cooked.
damn.
You're cooked. All right. The reason why you're cooked is because you said somebody. A lot of people do say that someone, somebody, but the term mastermind actually was coined by Napoleon Hill. Okay, he followed around Henry Ford and a lot of successful people back in those days.
I read that book years ago.
Yep,
Okay,
you
you're
already
right.
know. I know you know.
Yeah.
Mastermind is a collective group of individuals that come together to make one mind, and that's where we got Wisedome from, playing off of mastermind.
Yeah, we came
Um,
together to try to, filter out the sovereign and the legal and figure out what is law and what this all means because we were all new to this when it came in a few years ago. It's like, what in the hell is this?
yeah,
We need to get to the bottom of this.
This
we're
shit
just
is
now coming up on
really,
we're just now coming up on 2 years.
Yeah.
And what's cool is, bro, like literally in the past, I would say 18 months, people have gone in and literally there's over 50 dismissals, and like people are going in on their own and everybody's bringing something, like Marcus. He was all on A&E channel. He was on the news. They're saying he was running in a Maserati. Well, homeboy came through and put in a C4 motion, and he introduced us to the C4 motion process in Florida. And now everybody's bringing it forward
Oh
because of
yeah,
this.
motion is C4, especially on DUIs and do motion eliminating with them.
Hold
That's
on.
how I got.
So coming through, you understand and the state must respond with a traverse or demur, sworn by the way, right? Oh man, we see prosecutors start leaving real quick, passing on the case to another one, passing it on. Nope, we got to answer to that. And so I think what we've really understood, comprehended now is that first off, we're creations of the creator, right? Before anything, authority goes God, then it goes man, then it goes government, then it goes state or federal state, yeah, state, and then you got the county, and then you got the city. Most of these participants out here, as far as violating our civil rights, is at the lowest level of the totem pole, right? But people don't know that. If in their mind they know that they're just a slave and they don't have an understanding of that they are in essence part of this creation of life and existence. I mean, you don't tell your stomach what to do, you don't tell your lungs what to do, you don't tell your cells what to do, but yet that existence of knowing and intelligence exists, but that's not you. That's the great creator. So I think once we start coming back into that knowing, you start really incorporating the doctrines that we need, and such as the case laws. A lot of these we utilize Hurtado versus California and more, and the aspect that okay, check it. This is where I wanted to lead to because I've been holding off on it. We have had recognition of a statutory mode in framework of law and the body of framework of law that a court or judge will use or an administrator versus bringing in a different style document which invokes the constitutional framework and body of law. How do you distinguish the two as far as documents are concerned that you would bring into the court?
Okay, well, I'll give you an example on driving while suspended, for example. And you folks who are driving on a license, driving while suspended, you're going to love this argument. First thing you need to do is pull all the statutes defining the different lengths and periods of time for a suspension, the statutes that for revocation, the statutes of limitations for how long a misdemeanor, gross misdemeanor, or felony charge can be prosecuted, and also the statute expiration date. So one of the things, after I make my other objections, I'll ask the judge, well, Your Honor, I'd like to ask a few questions before we get started. And you say, well, sure, Mr. Ewing, go ahead. And I said, Your Honor, does the law require in the state of Washington that when you have two or more statutes regarding the same subject matter, that the specific statute will supersede the general statute? And he'll say that's correct. Now, Your Honor, does the law require when there's two or more statutes regarding the same subject matter, is the prosecutor required to charge me with the lesser but included offense if the lesser included offense is more applicable than the greater offense? And the judge will say that's correct. And Your Honor, does the statutes require the prosecutor enter a certified copy of a transcript from the Department of Licensing to establish and prove that I was driving while suspended on the exact date that I was charged with driving while suspended? He'll say that's correct and true. And Your Honor, if that same Department of Licensing transcript contains exculpatory evidence which completely absolves me of the charge of driving while suspended, would you not be required to dismiss this case on the spot right then and there the minute you see it? And he goes, that is correct and true. Well, Your Honor, the Department of Licensing transcript shows that my license expired December 8, 1996. Under RCW 462311 and 4604580, no driver's license shall be suspended for a fixed period of no more than 1 year. Therefore, the latest my driver's license could have been suspended would be December 8, 1997. Your Honor, it's 2026. So unless you and the prosecutor and the cop have a time machine and can take us all back to the traffic stop prior to December 8, 1997, you can't charge me with or find me guilty of driving while suspended because my license expired on December 8, 1996, pursuant to 462181. And Your Honor, can the state of Washington enforce the driving while suspended statute 462342 to render any other statute superfluous? Or does the law require you to construe all statutes together in para materia, meaning relating to the subject matter, to the same subject matter, construe them all together so that each and every statute is given the full force and effect of law so that no one statute renders any other statute superfluous or useless? And judge say, you're correct, Mr. Ewing, your case is dismissed. You have a nice day.
But let me ask you this. Okay, go ahead.
Or they'll tell me the cop didn't show up. Well, Mr. Ewing, I see here you subpoenaed the police officer, and I have no choice but to dismiss your case. And I'm saying, well, Your Honor, I object. That officer gave me a ration of shit in the traffic stop and said the judge was going to tell me differently. I want you to call him here. I took the day off. I'll wait here all day long. I'm there at 9 o'clock in the morning. I get all day, Your Honor. I want the cop to come here. The judge smiles at me and says, no, Mr. Ewing, we're not going to do that.
Now, check it. That would be under the statutory framework, right?
Yes.
Okay. How would you invoke the constitutional framework and body of law within that same court?
I would enter a certified copy of the 1878 Walla Walla Constitution.
Okay.
Certified with the seal of the state on it from the archives office. Okay. And it has a right to travel provision in it. And I have that in my.
I mean, Tolman was one of the greats as well as far as Supreme Justices here within Washington.
Oh yeah,
utilize him a lot.
But let me read this to you. Section 3 of the 1878 Walla Walla Constitution, which was approved by the 50th Congress, second session, Senate Miscellaneous Document number 55 on January 28, 1889. Section 3 says, all railroads in this state shall be deemed public highways and shall be free to all persons for the transportation of their persons and property.
Perfect. Wait, I'm going to pause you there because I'm going to come back to your statutory framework and I'm going to utilize the explicit notice of definition within said county and or ordinance code of street and then argue that it is vague. Okay, as defined. Why? Because if you're saying it's open as a matter of right for public vehicular travel, there's no clear distinction that I am required to get driver's license. Insurance.
This is correct.
Yep.
Now here's the other section. Article 2, Section 1 of the January 28, 1889 Constitution says, the Columbia River and the navigable waters of the state shall be common highways and forever free, as well to the inhabitants of the state as to the citizens of the United States, without any tax, duty, or impost therefore. And the Northwest Ordinance is consistent with that in the same language as the Treaty of Guadalupe. It says the waterways shall forever be free, the same as the highways. Now, the common law in Washington, the Territorial Code of 1881, this is the only law of the road for the territory of Washington, which, by the way, folks, state of Washington is still a territory. And the Code of 1881 supersedes all current RCW statutes. It says, Section 3030, Law of the Road, go to the right. Whenever any person is driving any vehicle should meet on any public highway in this territory, whether owned or kept by a corporation or private person, the person shall seasonably turn their vehicles to the right of the center of the road, so as to permit each vehicle to pass each other without interfering with or interrupting the other. And that's cited by Gerberding versus Monroe, 134 Washington 2nd, page 188. Now we go to 1915, Washington's Business Law for Businessmen, section 1351, Babbitt's Book, Section 1364, the law of the road. Highways are public roads, which every citizen has a right to use. The use of the highways is not a privilege, but a right. Now, that section of the code you're talking about, the current RCW 47.04010, RCW 46.09020, RCW 36.75.010, subsection 11, the Washington Administrative Code, WAC 296-32-210, subsection 46, WAC 296-45.035, and the Pierce County Code 11.02.030 defines public highway as, quote, every way, lane, road, street, boulevard, in every way or place in the state of Washington, open as a matter of right to public vehicular travel, both inside and outside the limits of incorporated cities and towns. RCW 463575.010, subsection 6, defines county road as every highway or part thereof outside the limits of incorporated cities and towns and which has not been designated as a state highway. See also Attorney General Opinion, Washington State 59-60, number 88, December 10, 1959. Attorney General Opinion 63-64, number 25, May 23rd, 1963. Attorney General Opinion 65-66, number 121, November 29, 1966. And the last one, AGO 1996, number 17, September 26, 1996. And I've got like literally half a dozen cases that cite this definition for Washington, the definition of a public highway as being open to the vehicular public as a matter of right, not a privilege.
Okay, now wait. I had to let you keep going. How does one change the framework in which the judges use from a statutory to a constitutional framework and body of law?
Well, see, here's the problem. You can do it, but to invoke the common law and invoke the prior constitutions, you do have to cite that statute, RCW 4.04.010, the common law.
Now check it. The thing. Okay, this is I'm going to tell you, like I've been doing, is this judge on the record in Stevens County here in Washington, he said, you've brought forth an 8.3 statutory motion, okay? But if you would, and I have to approach this as and in the statutory framework and body of law. This is literally what he said. If you would have came to me and submitted and to the court and notice and demand as unconstitutionally applied with points and authorities, then I would have had to look at it under the constitutional framework and body of law.
That's correct.
So what is very interesting about that and why I've utilized that so much over all this time is because it was explicit directly from the court and what he and how he would do it. Not that I'm sure that any other ones I've ever heard say that, because it is a very bold statement on the record for a clear distinction.
You're lucky you got a judge to tell you that. Most judges won't tell you that.
Well, it wasn't just me. We're watching another Luisa situation, okay, in Stevens County, Washington. And that's what the judge said as we're watching the court. And so, again, that clear distinction from that judge lets me know that internally most judges know that, okay? And the motion, I'm making a request to the notice and demand to dismiss as unconstitutionally applied with points and authorities to be more impactful, at least on the legalese and avenue or doorway, however you want to see it, in which one can actually obtain such, right?
Yeah. How close is Stevens County to Chelan County?
Well, yeah, Luis is probably, Chelan's north, so you're a little bit more east.
Because I have a friend over there named Bruce Bannister, and I think he's had some dealings with Stevens County. You ought to hook up with him. I can send you his info later.
That's the place where they call my boy a constitutionalist, claiming, sovereign citizen vibes. That was weird, So, yeah, it's very weird.
Yeah, I think Bruce Bannister, I think he's had some dealings in Stevens County Court before, so he might be able to give you the what's up on some of the judges there.
I don't be over there that much. All right, let me see what's happening now.
Got a quick question.
Yeah, go ahead, Chris.
Have anybody ever heard or signed a ticket non-assumptive without recourse?
No, I haven't done that. And like I said earlier about what Cameron was saying, uh, he said he hasn't seen it work, but I have seen those things work, but only for civil infractions, minor shit that they don't really care about.
Right.
Yeah,
That's the
I've
first
seen
time I
it
ever
work
heard
in a
about it. So
civil way.
cool. Thank you.
Sure.
So yeah, I guess I guess question into that is just to see like based on your experience how you would take one out of a statutory side and into like more of the constitutional framework side.
It's hard. It's really hard to do that because here's the thing: they can't really operate under the common law anymore. Okay, they are completely a statutory setup.
I know,
Okay,
but I
and the
know.
only way that you can invoke the common law is to cite the common law statute and the common law case law, and you have to cite the territorial code of 1881. Like many years ago, for example, I had a drunk driver, and I submitted a writ of habeas corpus using the Territorial Code of 1881. I did not use a single RCW statute, except I did, as a reference point, I put it in brackets, which under the law it means it's not part of the document. But I used it as and I told the judge explicitly in the document, I'm only providing this section of the Revised Code of Washington as a finding aid to show you that I'm using this section of the Territorial Code of 1881, which is the underlying session law, Senate bill, and House bill for the current statute, which is not the law. Okay, this is what a lot of people don't know. 1961, there's a case called Perosa versus Tacoma, which says the revised code of Washington is not the law, and it cites another case called In re versus Self. Now, the sovereigns get this mixed up when they say the statutes aren't the law. Well, that doesn't mean I punched you in the nose and you charged me with a statute. That's not the law. Okay, I ran the red light, so that's not the law. That's not true. Okay, when you read the cases, Perosa versus Tacoma, and read that case. The Supreme Court basically told the code reviser's office, like we've warned in layman's terms, we told you to stop tinkering with the statutes because you guys keep amending the statutes without authorization.
Mhm.
We hold that the revised code of Washington, which is not the law. Here's what happens, folks. At the end of the legislative session, a group of bar attorneys from the Code Revisor's Office here in Washington, other states call it the Statutory Law Revision Committee, a group of attorneys goes over to the legislature and say, okay, children, you had fun playing house, pretending to pass law. Give us those session laws, give us those Senate bills, give us those House bills. And they take those stack of session laws, Senate bills, and House bills, and they go back to the Code Revisor's Office and they close the door and lock the door behind them. They get their pencils and erasers around and they erase words. They change ors for ands and ands for ors. They remove complete sentences, they add complete sentences, and then they send it to a private copyrighted publisher and they put out a private copyrighted publication, which, by the way, Title 17, I believe, of the United States Code says the states cannot own a copyright. Okay. And so they print the revised code of Washington, which is only prima facie evidence of the law. So you want to look up here in Washington, the rules of statutory construction are contained in RCW Title 1. And the section, I think it's 1. If I remember this right, 1.01010. Okay. And one statute will say the revised code of Washington is only prima facie evidence of the law. And the next section, or maybe it's 1040010 and then 1040020. It'll tell you in case of any inconsistencies or omissions, the previously existing laws shall control. So underneath the revised code of Washington, I discovered we had something called Remington Revised Statutes, named after Judge Remington, who owned a private publishing company. Before Judge Remington, we had Judge Ballinger's Code. We had Ballinger's Code. He was also a judge. He had a private book publishing company. Before Judge Ballinger, we had Judge Pierce. So we used to have Pierce's Perpetual Code. Well, that's a private copyrighted publication. The last actual and only laws we've ever had printed in Washington was the Territorial Code of 1881. And here's the difference why the Code of 1881 is the actual statute versus the Revised Code of Washington, which is only a code. It's not really a statute because it's not the law. Is at the time of the territories, the people were electors. They had standing. The current persons now, all of you are persons now. You're not people. Okay? You're persons. Person, place, or thing. You're a thing. You're the goyim. You're a non-Jew. You're the beast of the field. human cattle, human dog, human pig, human swine. Ask a Jewish doctor, did you invent the swine flu shot for baby pigs or children of the Goyim? They'll tell you to get the hell out of their office. Okay, so go read the Reconstruction Acts. It says one of the main purposes of the Reconstruction Act is to change the legal status of the people from electors to registered voters. Registered voters do not have the same standing as electors. To qualify as an elector, you had to be a male. Women didn't have rights. Okay, women were the chattel property of men. They were no different than a black Negro slave. Women had no rights. They couldn't vote. They couldn't hold any public office. But an elector had to be a quote unquote a free white man. This has nothing to do with racism or bigotry. It's just that they recognize, well, we're white, so we have to have laws for us, and those are Indians. We can't make laws for them because they're their own people. They're their own nation. Okay. Back then, when people respected sovereignty of Indians, whereas white man's never respected nothing anyway. They just take what they want. So anyway, it says in there the main purpose of the Reconstruction Act is to change the status, the standing of the people from electors to registered voters. Registered voters do not have the same legal standing, they don't have the same legal status, and they don't have the same legal character as an elector. Now, to qualify as an elector, you had to be a freeholder and you owned a minimum of 50 acres of unencumbered land, which means you couldn't have any bank loans on it. You had to own the land free and clear, what they call allodial title, droit, all right title interest, double title. Okay, you could not have a loan or a lien on your property. Only a freeholder that owned 50 acres or more land had a right to vote, period. People don't have that right. People don't own nothing today. We are slaves. We are slaves, and people don't recognize that. Thomas Jefferson said it best: there's no better slave than the slave who thinks he's free.
Yeah, I mean, I guess so, unless one just really does live free. Like I live really free, bro. Like I don't, and, I have literally a contract with, rental company, individual. I have certain contracts with certain people individually. Beyond that, I live really free. I don't, pay the tax really as far as cars and tabs and all that kind of stuff. Like I'm living pretty free. Um,
Me too. Me too.
yeah, I mean, I live really free, bro.
Free is the thing because it's like how Cameron's explaining is really he has processed throughout time and organized and structured himself properly to where he's free. So like, what is free in your definition of it?
Yeah.
Well, can you leave the country without a passport?
Yeah. Yeah. I probably could. I would have to go about it in different ways than traditional, but privately, yeah.
Also,
So
when
here's
it
the,
comes to owning the land that you would, how do you feel about land trust? What is your
let
intelligence
me
on
go let me go
trust?
into that. Let me go back to the sovereign thing. Now sometimes like I'll mess with the sovereigns and I'll say, "Oh, you're one of them sovereign citizens." And they always like to come back with something cute or smart because they want to prove how smart they are. And they'll say, "Oh, that's an oxymoron. You can't be a sovereign and a citizen at the same time. You have to be one or the other, but not both." And I said, "Well, absolutely, you're wrong." Okay, number one, you can't be sovereign and a citizen in this country. You can't be sovereign in this country because you don't own any land. And the minute you stop paying property taxes on it, the government will come remove you from the land because you don't own it because you're not sovereign. And number two, how are you going to be a citizen? I mean, I hear all of you sovereigns claiming that the United States is a corporation,
Because
citing
we have a
18
duty.
USC,
Because we have a
18 US,
duty. We have a
18 US. Yeah, hey, okay, I'll hear all these sovereigns claiming that they're, the United States is a corporation, citing
check.
18 USC 3002 subsection 16. Can you be a citizen of a corporation? No. So
No,
you
but
can't, you
check it.
can't be
Wait.
either.
Okay, yes. But listen, you got to do it like this. Troy, you ready?
Yeah.
Well, hold on, Lewis. Troy, are you ready? Where you at, Troy? Listen, man. Sovereign citizen is literally in the citizen aspect. Again, they always try to claim something that had an original intent. Okay? And if you can go back to that original intent, you're golden. All right. That's whole act rule. And that's why you had the 1940 joint resolution for the creation of I Am an American Day, right? It
Well,
was because a citizenship is you as an American. And Troy has the best thing. We always read it. It's in the definition of magnanimity, right? Which is there is such a strong duty as far as being an American is concerned that you owe that respect, that duty, that gratitude of existence to every single person. So I think what's happened, because I'm a historian too, like big time on America specifically, but a lot, yeah, man, before Younger Dryas floods type vibe.
Here's the problem. Okay, you get one of these sovereigns in the court, whether it's state or federal court, and they will claim, "I'm not a U.S. citizen, Your Honor. I'm a state American national. I'm a citizen of the state of Texas or a citizen of the state of California, of the California Republic." And I just start laughing my ass off because they just put themselves right back in the federal soup they were trying to get rid of. So first they claim they're not a United States citizen, then they claim to be a citizen of the
But
Republic of
wait,
Washington.
why do they do that though? You got to look at, let's say not the state national or I'm not this or I'm not that, but let's just say you actually hit them with a residency rebuttal. Because we all know that there's a rebuttable presumption. Like let's take Iowa for example. I'll show you one quick example. This is pretty cool actually. Shout out Sarah for us finding this one. Iowa. Let's see. I think it's this one. It is this one. This one's cool. You'll find this one very surprising. And the reason I think you'll find it surprising is because, bro, it's literally in the motor vehicles and laws of the road of Iowa, right? So what they've actually done is they've buried very deeply in the motor vehicles and law of the road code statute. I don't know what you want to call these here. I guess it's maybe a statute or it's within the code rules regulations. But it says right off the top that there's a presumption of residency. Why would they hide that in the motor vehicles and law of the road for? For the purposes of this chapter only? Kind of weird, right? I find that to be very odd, but very obvious as well. That there is a rebuttable presumption that a natural person, so they're utilizing natural person as the ultimate here. Oh, dang it. As the ultimate, right, and there's a clear distinction between just person in and of itself and then natural person. If we're getting into statutory argument, clear distinction, they have different definitions for sure, is a resident of this state if any of the following elements exist. Well, I don't want to be a resident of this state. And again, the state, as far as its corporate and territory form is concerned, is they have a presumption. It's rebuttable, but it's still a presumption. So let me ask you this:
I
How would
have a lot of
you
case law. I have a lot of case law about presumptions and how to overcome a presumption.
exactly? So let me ask you this: How would you rebut their presumption? And just orally, would you do it?
Did I do not quote live in this state quote or within this state quote citing the RCW statute and the Federal Buck Act?
Okay, cool. That's cool. You could do that, or you could go through every single one of these letters here and not be one of those.
Right.
Do you get what I'm saying? They're literally telling you how to not be a resident, bro.
Yep.
And if you follow any of these, you will be deemed a resident.
Yes.
So that's what I'm saying. That's how I live free.
Yeah, but let me go back to pointing. Let me point out why I say about the person who goes into court and says I'm not a United States citizen, but I claim to be a citizen of the state wherein I reside.
Well, do you know about the three types of citizenship?
Yes.
You know,
but let me finish pointing out this point that's
U.S.C.
gonna. And let me finish something about this that's going to destroy those arguments. See, this is where all the state nationals and the sovereigns get it wrong. The basis. There's nobody home. This goes way beyond. Lee Brops wrote a book about 35, 40 years ago called There's Nobody Home. Okay. This is why the state nationals are always losing in court over this argument. Okay. So they first claim they're not a U.S. citizen and then claim to be a citizen of the state wherein they reside. Go to your state auditor's office and your state treasurer's office and get a federal tax ID number. The states in the original jurisdiction were destroyed. They no longer exist. Your state exists only as a corporation. It has a federal tax ID number. Is it a political subdivision and an instrumentality of the corporate United States? Okay, so when you claim that you're not a U.S. citizen and then claim to be a citizen of the state, you just put yourself right back into the federal soup that you're trying to get out of. Now, here's the second problem. Who's the governor of your so-called republic? That was all gone. Every state has suspended their first original de jure handwritten constitution.
Well,
There is no
also,
governor. There's no governor for that state. There's no attorney general for that state. There's no offices. That government no longer exists.
what about the charters though? See, because Robert, that's my boy Double R, Robert Risman. Then my boy, that's what he be about. And I need to figure
Robert
more
Richmond
about
is
them charters with
Robert
him, boy.
Richmond is way smarter. Don't get mad at me, folks. Robert Richmond is like 1,000 times smarter than all you sovereigns, and you guys are all looking for the easy way out, the quick way out, or the cheap way out, or the free way out. Most of you guys will never be able to argue what Robert Richmond argues.
You say us? You talking about me and us?
I'm not talking about you, but I'm talking about your
What about the
audience.
rest of my audience? Oh, out there. You talking about out there?
Your audience out there that are trying to learn, the beginners
Yeah.
in this movement.
Oh, yeah. Everybody, y'all can unmute though and say not me.
I got a real question though. Real
Go ahead.
question.
Robert Richmond is a fucking genius. Okay.
Yeah, that's my boy, and that's what I'm saying. Like, that's why I really bring out, like my boy Robert be saying, them charters though.
Look, I think what
Not
it is
me,
people
not
what
me.
they try to do is default themselves to natural in the United States, and that's defined by 8 U.S.C. 1101 A22. So
That's
there's
correct.
3 types of citizenship, and then the other one is 8 U.S.C. 1408, but that's only if you're legally applicable. You know what I mean? But there's
Well, here,
also a national to the state, which gets noticed out to the Secretary of State, the DOJ, to White House, AG, and whatnot. But there's a certain administrative process that people undergo to do that. But it's not necessarily, yeah, there's like sovereign citizens where, like what you're explaining, these people who just go all the way off the edge, they're mentally lazy and don't want to actually learn and, articulate and
Silver
actually know
bullet,
the context of
silver,
what
I
they're.
want to tell
silver
you how
bullet filings.
I want to tell you guys how the courts are trumping all your arguments. Okay.
Because no one's actually attacking the procedure, the statutes, and following the courtroom rules as well.
Yeah,
They
that's
think
Okay.
that they can make
You
different
folks need to read.
hallucinated case laws,
Okay. A lot of you folks will argue about whether, Martin Luther King said we live in a democracy, which is probably the only honest thing he ever said. And other people say, no, we live in a republic. And I say, well, we were supposed to live in a republic, but we don't. Okay.
1913.
We don't live in a republic. We don't have a Republican form of government. And then the other people who say we live in a democracy said, no, if that was really true, then the majority vote would win every single time. And I've seen the electoral vote overcome the popular vote at least 3 times in history. So we don't have a true democracy either. And the proof of that is you need to read 2 cases. One is called Texas versus White and Luther versus Borden. When you read both those cases, it'll tell you most American people don't know this, but we do not live in a republic. We do not live in a democracy. We live in a permanent provisional military government. Now, the proof of that is you Google Revised Code of Washington. I want you folks to look up Title 38, Chapter 38. It's entitled Militia and Military Affairs. Every state has a similar chapter in your state statute books called Militia and Military Affairs. Well, when you read the entirety of Chapter 38, Militia and Military Affairs for the state of Washington, it tells you every agency and department of the state of Washington is directly under the control and supervision of the military. We live in a permanent provisional military government. This is why the president can send troops off to foreign countries. He doesn't need Congress to declare war. We don't have a real Congress. We haven't had a real Congress since 1860 when Congress walked out, sign a day without sun, never to return. That Congress is a corporation advisory committee, and that's all it is. They have no power.
Okay, and that's why I think what's been really amazing with Operation Wisedome, and just the people in general all across the states that we have initiated, at least bills and acts into thus far, is, starting to see that we just need to tell them what to do in a sense. I
Okay.
think what's been the problem is that a lot of the people who are learning and they come to learn, I don't want to say they're ignorant, even though a lot of, we are all are ignorant to a lot of things. Even I'm still ignorant to things. So
now I'm gonna flip you back to the
hold on. Is that if you just really start trying to say what to do. And a lot of us were coming into this whole movement for so long saying, well, I just need to stand all on my own for this, and I need to learn a way outside of it to protect myself from the system. Rather than saying, you know what, there's enough of us that want goodwill established to every living being, and we want to actually change what's happening to our fellow human beings by comprehension, knowing, empathy, um, morality, and integrity being at the forefront again. And I think more than it's saying, okay, it's us against them as far as a corporation, even though it still is, again, that's the business that we own that should run itself the way we want it to. And just like any company that we own, if we're not willing to stand in and say, you know what, this is wrong that we're doing this and allowing our company to do it, even though we're making lots of money here, we need to implement some changes. Because I mean that, and that's the whole point of the bills and the acts, because people are going to speak up when it comes to this. They are tired of paying the fees. I don't care if you're a law-abiding driver's license. You have your driver's license. You make sure to keep your insurance up and you keep your tabs up every year. I guarantee you that most of those people are like, why can't I just not have that? Why can't I just take a test, maybe have one plate that will identify me with the rest of my life, saying that I'm a free traveler and I don't have to pay anything? And the only time that you can mess with me is if I'm violating, speed limits, road signs,
The
causing
law of
posing a
moving, by
safety
the way.
risk to other people. Why isn't that just the go-to? And why can't we make that clearly happen? Because it doesn't matter if you're sovereign or not. Everybody wants that, bro. You can't tell me that I'm asking for people not to have a driver's license because I don't want them to be able to get identified in some form or fashion. That's not true. Because if my daughter's out there driving, or any of my kids, or my loved ones, my mother, my father, and something happens and you just get away and there's no way to identify you, where's SOL, homeboy? Right?
Yeah,
So
we have to apply it towards public safety.
yeah, there is the only reason that one should be engaged should be in relation to pose safety risk to another. Whether again,
Exactly.
that's speed, well over the speed limit, that could cause a grandma or a young one, you got to think, bro. It's about respect.
Yeah, we're not trying to avoid
I'm
we're not
tired
trying
of
to avoid
making, I'm,
accountability and responsibility.
yeah, I'm
Okay.
tired of making excuses and saying, well, you got to do this and you got to do that. No, it needs to be plain and clear for every single person, just like in the 60s and 70s. What they have in the schools, they literally had
If you
driving
decide to
education
contract, you
classes.
contract with them.
They had driving education classes, bro. So coming out of high school, they already knew how to drive a car because you learned it in school. So there wasn't no problem on having to go outside to pay it, then to get a driver's license and to maintain that bad boy forever and pay every single year. That's crazy. Now I have to go wait in line. I have to put it up, strip it off. It's a waste of time. For what? What? So that's the
Especially the
point.
fact that the
And,
contract that
I'll
you're
and I'll tell
signing
you
is
that
never debriefed to you fully.
That's
I'll
why
tell
these
you
right
that,
to travel acts, hold on, because Matt's, coming in wanting to speak on it. But that's why this right to travel act and this right to travel and traffic law reform petition that we're doing needs to get serious scrutiny because it's harming our people. People getting taken to jail for driving without a driver's license. That is not cool unless they've posed a safety risk to somebody else. Okay? Not having insurance. We're taking it to jail. We got to take it to jail. Why? 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 That whole scheme of things and money that is being sucked up by all of the agencies is what can go back into our economy, more to the small businesses, more to city and county initiatives to build the community. Think about how much more empowered and enriched people would be off of one small initiative, which is take a little bit of that money that we're always sucking up from the people through ticketing and put it into every 5 blocks, put a community garden of at least 2 to 3 acres
Yeah, do
in
that.
subdivisions.
Yo,
What would
what's
that one little thing?
I
what's
got
up
some
with
good
the
news on
court
the right to
registry
travel.
investment system, and where does that money go?
It goes to them buying new equipment. It goes to them
We
getting
can
a souped up
compel
car.
all that.
Because isn't the compelling public interest of the court supposed to be the highest general welfare? So why do they get to have like slush funds and timeshares in Lake Tahoe from the court registry investment fund? And why is it so like obfuscated if the public tries to access where the fund goes and how much it grows?
The only problem is there ain't people like us putting them on notice about it and holding them accountable and forcing them to produce all the evidence of what they're actually doing with what they're doing with our money
Hey,
and when they
can,
reap the money from us and what they do with that.
But when you say us, you're
They
not. But when you say
we
us,
have
you're
to
not.
get them now to start showing it.
hey, Cam, can I ask Lewis a question based on right to travel here and a case in Washington?
Yeah.
So I heard about a case in Washington in the last couple of years about on the cars how the temporary registrations they had to move them from inside of the window and they had to start putting them outside of the car on the placards because of a contract issue with the Postal Service. Have you heard about that?
I have not heard about that one.
So apparently they're saying that, since you can have two types of carriers, private and public motor carriers under Title 49,
Oh, 49. Yeah.
apparently the carrier is some kind of, postal thing. And so there was a case that came through that they can no longer put the temporary registrations on the inside of the window. They have to put them on the outside of the car, kind of like a bill on your bills, and they got the window on your envelopes they send you. So
Right.
you hadn't heard about that?
No, but I'll tell you something. I pretty much have almost completely perfected the right to travel for Washington because I've drafted flyers showing that the state of Washington, like every other state, only sells commercial driver's licenses. Now, I've read the entire motor vehicle code from 1905 when they first licensed the car. I've read every session law, every Senate bill, and every House bill for the motor vehicle code from 1905 to 1915 where they first licensed the driver. And I've read all of that stuff. I spent thousands of hours in the archives in Olympia. I've read that all through about 2017. It's probably time for me to go down and catch up. But write this down. 40 RCW 46.25.080. It's the one and only license classification statute in the entire motor vehicle code. I have it in my
Can
flyers. I can
someone
send
write
it
it
to you.
down and put it in the chat, please?
You can send me an email to rcwcodebuster at AOL.com, yahoo.com, gmail.com, or protonmail.com, and I'll send you this flyer.
No, I got a question on this matter directly because there's always a jam when it comes to like an officer in an interaction where I observed, and 90% of the interactions is it always comes down to that the state or the policy is what is enforcing and regulating still through like DMV and the state itself that you are required to have that driver's license, whether you want to term it commercially or not, because you're using the roads like how Cameron previously brought up the roads as definition and streets as definition and how they're vague.
Well,
But
you had to
what
cop
is
my
the way
you had to cop my flyers, and you'll stop them dead on the spot. I tell the cops, if you can show me a license, a statute, an RCW statute that says I'm required to have a license that's not commercial, I'll show you an RCW statute that says I'm not required to have a license. And the cops will say, if you can show me that, I will let you go. So 4625080 says license contents, classifications, endorsements, restrictions, expiration, exchange of information. Number 1, the commercial driver's license must be marked commercial driver's license in quotation marks or CDL. A, licenses may be classified as follow. I, Class A, II, Class B, III, Class C. Now, folks, I don't know if you know this. You guys aren't, I don't think you guys are old enough, but 25, 30 years ago, the old driver's licenses in Washington, on the back of the driver's license, it said in all capital letters on the back of the license, commercial classes. Ask your parents to show you their old driver's license. It said commercial classes all the way, capital letters all at the top, and the left-hand column would say Class A, Class B, Class C. They've actually changed the physical appearance of the driver's license no less than 4 or 5 times in the last 20 years because of me. So they took that designation and they changed it to the organ donor card because they're planning on running me over with a big truck so they can sell my body parts. So they took that statute and they still complied with the law. In the front of the driver's license, they put in small print CDLEND. That's still the abbreviation for commercial driver's license endorsement. So about 10, 15 years ago, you would see that in the driver's license, CDLEND on the front of the driver's license. Now, they removed it. You can't see it there anymore. So where is it? Because that breaks the law. The statute requires that it be marked commercial driver's license or CDL. What they did is they put it in the barcode. They put a barcode on the back of the driver's license now. So when the cop puts your driver's license into his little ATM slot in his car, he can read what kind of license you have in his barcode reader. So I'm gonna tell you a trick here, folks.
People fail to see in the Florida on your driver's license in Florida on the top left corner, it tells you right there it's not your property with a citation.
Now here's the funny part. The cops will tell you 4620-001, license required, rights and restrictions. No person may drive a motor vehicle upon a highway in the state without first obtaining a valid driver's license issued to Washington residents under this chapter. Now, the judge will say, Mr. Ewing, you're in the wrong chapter. You're reading about commercial driver's licenses. You have to go see RCW 4620-001. And I go, well, Your Honor, 4625-010 definition says the definitions set forth in this section apply throughout this chapter. Subsection 3, commercial driver's license, CDL, means a license issued to an individual under Chapter 4620 RCW that has been endorsed in accordance with the requirements of this chapter to authorize the individual to drive a class of motor vehicle code. Well, 4625-080 says there's only 3 classes of driver's license in Washington. Class A, Class B, Class C, and they're all fucking commercial. Every single fucking one.
When the Department of Licensing, so just some personal experience here as far as November 2025 is concerned.
Now, here's this flyer, my recreational vehicle flyer, where I show the cop. He says, if you can show me a statute that says you don't have to have a driver's license, I will let you go. Okay, 4625-050, subsection 1, drivers of commercial motor vehicles shall obtain a commercial driver's license, ... means I skipped something out, I omitted something. However, this requirement does not apply to any person, subsection C, who is operating a recreational vehicle for non-commercial purposes. Now, the WAC that defines the recreational vehicle, WAC 308-100-210, recreational vehicles definition for the purposes of RCW 4625-050, subsection 1C, the term recreational vehicle should include vehicles used exclusively for non-commercial purposes. There we go, non-commercial, which are, number 1, primarily designed for recreational camping or travel use. There you go. I just gave you the RCW statute that codified the right to travel.
Hey, Lewis, but doesn't that still refer to CDL licenses? Like, I see that it refers to CDL, and even so I cross-referenced it for Florida, and it's the same, but it's for CDL licenses, not a regular driver's license. So how does that still work?
The CDL, okay.
Or is it that all licenses are still commercial anyways?
They're all commercial because even though they tried to pretend to make a commercial license over here and a regular driver's license over here, when you go to the footnotes at the bottom and it traces the prior statute, they all lead back to the 1915 Jitney Act. Every state's motor vehicle code was originally called the Jitney Act.
Well, check it.
The Jitney.
Check it. So when it comes down to it, this is a Department of Licensing report, okay? And they're pretty much showing the driving record. This is me, okay? As you'll see, though, there's no license issued or license expired. That's why every time that they pull me over here, they're like, well, there's no image of him in the system. I'm never applied. There's no picture of me. And
you cannot be suspended. You cannot be suspended or revoked. You're expired.
Well, I'm not expired because I've never even applied for one. So expiration can't apply either. Nope. And so when they're showing, hold on, just let me explain this real quick. So when they're showing, you can see the distinction between a personal driver's license status here in Washington under the DOL and then a commercial driver's license status. They're suspending and revoking over here. What are they suspending and revoking, though? Not any valid license because one does not exist. As you can clearly see here under PDL/CDL statements, no valid PDL had not been issued a valid WA license. Okay? But they're still suspending something. What are they trying to suspend? Which could honestly go against they ass for real. It would be they're trying to suspend the right to apply, just like Oregon does. If you don't have a license, they'll suspend the right to apply. Well, even if you try to, you can do that. Right? You can suspend the right to apply. Why could you be able to do that? Because now we're in the commercial realm. And what does the government regulate? Commerce. So do you see how now we get that distinction as well?
So I have a flyer for driving while suspended. Aberdeen versus Cole. On appeal, the Superior Court dismissed the charge against Cole on the ground that since he had no driver's license, he had no privilege to drive, and therefore he could not be charged with driving while such a privilege was suspended. In State versus Markley, it was held one who did not have a driver's license could not be charged and convicted under this section. License is synonymous with privilege. Since Cole did not have a license and that state did not grant Cole a license, the state cannot suspend what he does not have. Now, talking about what you were just saying, State versus Hague, automobiles, operator's license, reinstatement, administrative error. A driver's license will be deemed to have been reinstated, thereby precluding a conviction for driving with a suspended license. The situation is comparable to that of a probationer who is put in jail for 60 days as a condition of probation. At the expiration of that time, he is entitled to that freedom. When that time expired, he was entitled to his license. He was deprived of his liberty to drive without due process of law. Thus, the conviction must be reversed. State versus Hague. Okay, so you combine the expiration date, the suspension date. You take the Department of Licensing notice of suspension. It has a beginning date and an ending date of that suspension period, at which time you're eligible to reapply for a new license if you wanted to apply for one. At that point, not only are you expired, you're just driving without a license, which is a civil infraction under 4620015.
Yep.
Okay.
Yep.
In Washington, there's two driving without a license statutes, 4620005, which says driving without a license a misdemeanor when provided. However, like if you show the cop an expired license at the time of the stop, it says don't use this. Don't use this statute. See 4620015. When
Right.
you go over to 4620015, it says a driving without a license a civil infraction when you're expired. It says it used to say it's a non-jailable offense. They took that out because of me. And they also put the maximum bail was $250. You know, the maximum penalty, not bail. The maximum penalty is $250, and it used to say a non-jailable offense because yeah, you cannot be arrested and taken into custody for a civil infraction.
So I have a question too. I see a lot about like the DOT process and people who are traveling with their passports, and when they're pulled over, they're getting on the officers are getting do not detain. Could you speak a little bit on that?
Well, I gotta tell you something funny. They say the guy is dead. I'm trying to remember his name. David Strait.
Yeah, he died.
Okay. Well, I have other information. A little bit about that. We'll go into that later. David Strait, about 3-4 years ago, he got pulled over for driving without a license, and a lot of people in the Republic of Texas are pissed off because he got away with selling them almost $200,000 in fake license plates. And he told everybody if you filled out his special magic paperwork that and get a new passport as a state national, that allegedly they'll put all of you on a do not detain list if you buy his special paperwork to apply for a state national passport. Well, he got arrested for driving without a license. Okay, he went to jail and he had to post bail and whatnot to get out. Around the literally same time his wife was arrested. I think she's serving time now. Literally, about 2 months, 3 months later, I got charged with driving without a license coming out of Highway 101 out of Olympia. I don't have a special national state passport. I have a regular quote unquote U.S. citizen passport, and my passport was expired. The cop let me go on an expired passport. I didn't have no special magic national paperwork. But I got let go and he went to jail for a civil infraction. And he didn't even know to tell the cop that you can't go to jail for committing a civil infraction. Because under Oregon law, Texas law, he's from Oregon, I guess. But in Oregon, driving without a license is a civil infraction. The same thing in Texas.
And so then what are you essentially saying in that? Are you essentially saying that it has no applicability?
Yeah, I was gonna say I'm not sure really where. Like it seems like that was just a specific your case situation, like not how it would generally be recognized.
Well, David Strait purported to be the leader of the state national movement and was telling everybody that his state national paperwork would put you on a do not detain list, and he got arrested.
I mean, I've never really seen a readout. I've never seen anybody really confirm the do not detain, as much as I've really sought to have that brung forth from someone in relation to doing the passport alone, that's not on any special protection, I would, I really would like to see that. I
Can I
mean,
say something?
Here's my advice.
I think people have it kind
Jeremy,
of falls
Jeremy, you're
into
muted, bro.
the 5-star passport stuff too. If you know anything about that, I don't know if that's even legit, but I've heard it is. I don't know. I don't know what to think. It seems pretty confusing, this area of topic.
Well, here's my advice.
It is about the trust. I'll tell
Here's
you
my
that much.
advice.
Hold on. It is about the trust.
Can I say something?
Yeah. Hold on one
It's
second, if you don't
yeah.
mind. So it is about the trust. When it comes down to it, I will honestly tell you, I don't care who you put in front of you. There is no other person I think that is more structured and has shown more progress and work and eligibility and confirmation with a very long standing like Avery at the 0%. I will give my boy his flowers all day because he is one of the only ones that has pulled himself in the very, very beginning out of the $14 quadrillion agricultural lien that's placed upon you and all property here in the United States by your government. So when it comes down to it, I don't care who wants to say I'm the best at trust and I can do this. You're not better than Avery because I know you're not. If you were, you wouldn't be in here. In a sense, you'd be actually right at the top, helping me push whatever we need to push, which is what I need to do with Avery. But when it comes down to solid knowing and comprehension, um, these contracts and these things on the back end with the trust and the protection with the registration and everything like that, there can be a way where you get do not detain and move about your way in a trust aspect. But I don't think it's necessarily just a state national type passport. I think that's a little bit far fetched, me personally.
Here's my advice to everybody. Do not take legal advice from somebody who could not provide you any court case cause numbers to prove they've won their own case or that they've won cases for somebody else in the exact area or subject of law you're talking about. I don't care if it's criminal or civil. If they can't show you proof of wins, they're bullshit.
They're bullshit, bro. And that's the whole point of it all is that like my boy Avery's been doing it for quite some time. The integrity and the foundation of everything. Hold on one second. What's up? Uh, the foundation of everything. Hold on one second again. And
Now I'll
so,
tell you guys something about the right to travel where everybody's missing the boat.
I'll just say something. You guys are talking about David Stray, and he passed. A lot of this is trying to figure out who is legit and who's got the proof. That's why I linked up with our boy Cam here because he's showing proof. But and this is off topic, so I'll just mention it briefly. I know that the wife Bonnie is doing debt discharge, and she guarantees it, and this and that, and I don't even know if it's legit or what. She sounds scammy to me, but I just want to throw that in because you guys mentioned David Straight, and not take us off topic. So, yeah, she's offering debt discharge and can't get my car note and my bills and all of that
yeah,
wiped off. I
I
don't
think
know
People
if
who
it's
make
legit or
promises
not.
are most likely bullshitting you.
I think
Yeah.
there are some successes within every single person probably in some way, form, or regard. And everybody's on their own level as far as where they need to be in life, I do think, and whatever placement they need to help benefit everybody. Everybody's at a different educational level, man, intellectual level. So
Right.
but if you're on the top dog where you're going out and getting a Porsche and within 3 months, that Porsche's paid off because you understand the process on monetization of notes, contracts, and applications, and what format they actually use as far as a OC7 or OC10 operating agreement with the Federal Reserve, then you can understand the monetization of said applications and move forward in a knowing manner. And that's really all it boils down to is how am I structured? What do I know? And how can I proceed with the rules and policies that are currently in place? It's just knowing those rules. Once you apply those, you bring forth the understanding rather than going into the court without having any understanding, thereby letting them run you over. I mean, let's just keep it real. The education has been dumbed down so much that a lot of these judges don't even have the knowing if you're coming with clear track record of things, right? A lot of them don't. Some of these cases where we've seen successes, like Avery and a lot of others within 0% is that these judges just don't know, bro. They have no clue whatsoever. And they have to go by procedure on things. And when you go by procedure of knowing, you're able to put yourself into a bracket that's able to really comprehend without falling into like frivolous bullshit. It's very simple. It's OC10 agreements with the application. It's all accounting. So all the Federal Reserve is doing is monetizing your application, right? And they're getting 30% off the top, off the interest. That's already paid to them, so they double dip. So what do you do? If you're going to bring forth something, it must be protected by the trust, and you must come with sound proof of that and say, this is the comprehension of what I know is going on and can prove it. And if they can't prove it, then your claim is true. If they can't disprove your claim, then your claim is true. I mean, every complaint is known. The court has to take everything you say as a fact until the defendants prove otherwise. That's how it works in federal court on at least 1942 claims, right? So why not put them into that situation in any court that you go into? I know that there's a OC10. I know that there's a OC7 ocular circular agreement, right? And really pound hard on the monetization of the note and where that monetization came from, right? But yeah, when it comes to the trust, bro, like I've learned a lot from Ewing, and I think that if you structure yourself up in a foreign trust the best way, even though I haven't done it yet, and we're going to start up Tuesdays here soon once we move.
You
Hey, Cam, I
definitely
just want
want
to
Cam,
to
I
say,
you want
also
definitely want to put things in a trust and not have things in your name, and I would recommend an offshore trust so that you would be beyond the reach of any of the courts in the United States.
hey, Cameron and Lewis, I actually shared in the chat Daniel Garcia, who actually shows lots of proof and teaches, puts his number for contact for discharging debt and everything that you guys were just covering. And yeah, I just wanted to let you guys know that way no one misses it.
Yeah, no, like we have people that's the debt discharge ain't really that hard, and we got a lot of wise domains in there that know about that.
But here's the thing: you can't pay a debt at law with Federal Reserve notes. You can only discharge the debt. In 1998, I forced the former governor of this state, Mike Lowry, to convene an emergency special session of the legislature to change the definition of money codified in our state property tax code at RCW 84.04.060. It used to say money shall be held to mean gold and silver coins, gold and silver certificates. When you look at it now, RCW 84.04.060, it says money shall be held to mean coin and paper money issued by the United States government. The funny part about that thing is the legislature's running around they're like a chickens with their heads cut off. Mr. Ewing screwed us up again. Everybody's not paying their traffic tickets. They're discharging the debt. With Louis Ewing's one-page promissory note.
Hey, now let
Okay.
me ask you this: have you heard about our right to travel bill that we're pushing really hard in Wisedome?
No, but let me finish this point. The statute money now says shall be held to mean coin and paper money issued by the United States government. The funny part about that is I have the case law that says the Federal Reserve is not part of the United States government. So the Washington legislature just passed a statute making it impossible to pay a fine. That's crazy. Look it up. RCW 84.04.060. Money should be held to mean coin and paper money issued by the United States government. The United States government doesn't issue coin and paper money. They don't.
Right,
You can't pay a fine in Washington State because of that.
right. So, are
They're
you
going to
familiar?
find a way around that because of the various three names on the trust, one of them being the Secretary of the Treasury. They're going to say the government does issue that. That's going to get kicked all the way up to the Supreme Court. It's going to have to, I would assume, to truly get adjudicated.
Well,
I
wait,
would
have you already
think.
been working with it have you already been working in that regard or what?
No, not at all. I'm just listening to what was just said, and just coming to that conclusion that they're going to use that. Well, because it's signed by the treasurer, it is thereby issued, even though it's part of a trust action, three names. And they'll stand on that until we prove it wrong all the way up at a much higher level.
You could just say it's authenticated at that point.
Mm,
Not when I'm
we
getting
could.
traffic tickets dismissed at the first level. How's it ever going to get up there? I've never had to pay child support. They won't even summon me to court, and supposedly I owe more than $75,000 in back unpaid child support. There's an RCW statute and there's a federal statute that says if you owe $5,000 or more and unpaid back child support, they're supposed to issue a felony warrant for your arrest. They won't even summon me to court because they're afraid I'm going to get clients in the courtroom.
Okay. Yeah, I just wanted to tap in, man. You're like you're nuts on this thing. You actually know a lot. I'm so happy to have met you. I want to know, I guess, what kind of topics do you want to? I guess you're talking about your Gray Lord. That's been something you're working on. Is that kind of like your baby right now? Is that what you're really focused on?
That and next year, I'm gonna blow the water. I'm gonna blow the hood open on right to travel. Like I pretty much mostly conquered it for just Washington State, and I've got recreational vehicle flyers for Oregon and Idaho and Utah that shows that you don't have to have a license to drive that. But um, I am doing the work right now on perfecting a brief system that will beat every right to travel, every no driver's license argument across the entire United States.
Yeah,
It'll
but
blow
we
it out of
got.
the water.
I know, bro. But instead of people have, I mean, I guess. I mean that is the thing. It's like, okay, do us now, we as the people, want to have something that's already in right now at this time showing that we know and you're no longer going to violate us or we're going to bring forth a civil suit, right? Which is what most of the people have been doing anyways here within Wisedome. And is that going to make changes or is it going to take a coupling of people that are also driver's license to understand, hey, look, it's not like we're trying to end driver's license um, in all forms or fashions, which is what they think about. Like you don't have to take a test just to make sure that you're competent enough to be on the roads and that people can just drive wild out here. That's not what we're proposing at all. I think it's just the fees and the eligibility of the officers to take anyone to jail based on utilizing a right. And I don't.
But the law is the law. And before we can make laws, we got to know where we're starting from. And we don't even know where that's at because it's been fucking manipulated for so long.
And see, that's what I'm talking about is going back to the law. Everybody wants to talk to the right to travel way up here issue, and they failed to go back down here to the beginning. Why do we have to have a license and what kind of a license it is and what is the license for?
Right. And because it's for commercial use, which is a valid reason to have a license and authority to keep, these semis from killing people and using the roads the way the people granted these corporations to use. And the way they've done it now, though, is they've actually endangered us and that statute by applying that to the people rather than to commercial traffic, because it's easier to apply to the people than it is to commercial traffic. So they basically have just fucked up the law.
Dude, the Commerce Clause of the United States Constitution
Exactly.
only gave Congress the authority to regulate interstate commerce from state to state and intrastate commerce from within the state. Now, there's body of case law that says the states have a quote unquote concurrent jurisdiction up to a certain point to regulate intrastate commerce. Okay. Which means they can require licensing and registration of common carriers, private carriers, and contract carriers.
But not private carriers.
But they're failing to make a distinguishment between a carrier and somebody who's not a carrier.
But they do. They got a private carrier and a public carrier, and that's all in 49 U.S.C.
But are you guys? But a carrier is still somebody who's operating for money.
Right. Well, not a private carrier.
Are you guys aware that you can actually get a non-commercial DOT? That's why I was asking about the DOT because I have one. So
let's check this out. So like
49-13-506 is the private carrier statute.
And who said they have the DOT?
I got a DOT, but honestly, I feel like the DOT fails the strict scrutiny test even for us because it's really not that clear. And I have a private interstate non-business passenger U.S. mail thing, but
it tells you right when you sign up for it that right on the website it specifically states non-commercial in parentheses non-business Department of Travel number.
No, it's
So I actually
Department of, wait, wait,
emailed
wait,
the
wait, wait, wait,
DOT
wait.
after I
Department,
made my DOT number and I told them
wait,
what I was doing.
wait. You're starting to confuse Department of Travel with Department of Transportation, bro. If you're gonna say, you're gonna say, have to say it right. It's not the Department of Travel that's issuing out no DOTs. It's the Department of Transportation. And what does the Department of Transportation regulate?
Commerce.
Commerce. You're under the Commerce Clause. So that DOT plate is for commerce. That shit don't save you. You want to know how many people are in here with valid DOT plates that still went to jail, still had to go and take their shit on appeal? Not because they didn't know how to argue it, but because, again, you're putting yourself into the commerce realm.
Well,
So,
here's the trick, Cameron.
Yeah,
Title 46,
DOTing is
Title
literally
46,
putting
whoa, whoa,
Title
whoa,
yourself in
hold on.
commerce.
Hold on, here's the trick. Title 46, the Motor Vehicle Code, and Title 47, the Transportation Code, used to be together. They split them in two.
That's what I'm saying. You
Well,
can't
Well,
utilize.
then you got to look at the highway
it,
code too, also.
when I emailed the DOT and I told them I was using it for private, non-commercial purposes, and I wanted to make sure to clarify, they said that I was exempt from the UCR registration and like updating the insurance information. And they said because you're a private intrastate non-business carrier, you're not required to adhere to like the same DOT checkups. And the way I interpreted it was like, yes, the DOT manages all like commerce and trade, but because of like the state and nature of our country and how it technically is like the law of armed conflict, because we're still under the Reconstruction, like we have a duty to notify who we are, just like the same way like if some guy's traveling through Afghanistan in a war zone, he has to indicate that he's a non-combatant. That's how I looked at it.
Well, I think that falls in line with notice liability, and that's why I say that's a good train of thought because I do the same thing. You know, if I know I'm going to be traveling through multiple jurisdictions, right? Because there are, as far as corporations are concerned, counties and or bodies of people, it's just like in the olden days. If you're not putting one on notice, right? Like you said, through notice of liability, you may see some extraordinary actions or presumptions being brought forth against you. And that's really just how you have to start really thinking about it in life. Like, hey, I'm about to go travel through these other peoples over here, this group of people, this tribe over here's territory, right? And I need to go to their highest law, sheriff man or whoever that may be, and put them on notice through a notice of liability. That way you can, again, enforce the good faith aspect that I told them not to violate my rights. I put them on notice that I'm standing in my full capacity as far as what I know, not going on with the whole, I'm the living man and breathing, but you can say, I know my creator endowed rights. I know I'm not unalienable and things that cannot be done against me. I'd like to put you on notice and see what you think about this. And having those initial conversations, what does that bring forth? What brings forth good faith? Because you can go in and say in any suit, especially you bringing it, that I went to talk to y'all and I'll put y'all on notice. And notice is the highest form of anything that I can do that I know of that is upon you, which is a sub agency of me, because you serve me. Because I don't violate crimes. And when you are setting up yourself in a good faith aspect like that by putting one on notice, again, the highest form of anything, you're you're setting yourself up for good eligibility to bring forth any travesty that's brought against you without having due process. Which again, we all know they can't just take your property just because they say that you didn't enter a contract or that you had a contract that's invalid. There's still due process here, right? And anything that goes against the Constitution is null and void ab initio. So we're gonna have to, like I say, I feel like it's these bills. I feel like these acts. Yes, we can keep fighting right now, and we're still winning right now. There's no doubt about that. We're championing on. We got some champions, bro. There's a lot of dismissals. We got people learning. It's just how can we get to the next level of making sure that these bills and that these acts start getting enforced as we're sending them out? Because we're like on the ninth, 10th state now. We got California done. We got Washington. We got Oregon. We got Florida. I think we did Georgia. We did New York. I think we're gonna start moving into Colorado, Pennsylvania, start kind of scattered. We got Texas, right? And I, I don't think it's about money. Some people will campaign off of, oh, I need money to go do this and go do that. I don't think it's about money. I think it's about people just actually backing up their state and saying, yeah, bro, this whole I gotta pay every year for registration is bullshit, and I'm tired of it, right?
Well, I think a bigger movement on it also is the surveillance state that's moving in across our country like a freaking stampede of buffalo. And that's really putting people on alert too. to start,
Flock stuff.
Hey,
the
Cam.
flock stuff, the AI
What
data
was the
center, all
trick?
that stuff.
Hey, what was the trick between U.S. Code 46 and 47? Yeah, they're separated. So what's the trick to that? As you were mentioning, I forgot your name.
Lewis Ewing.
Yeah,
They
Lewis,
wanted
sorry,
to
bro.
make it look. They wanted to make it look like the driver's license is not commercial. They wanted to separate it.
So the trick is to point out these things aren't separate. They're a continuation of one's continuation of the other. That's
Yes,
the trick.
everything we read today is misquotes of the law. It's an amendment of an amendment of an amendment, but the prior law controls. For example, everybody thinks the Washington State Patrol has authority over you. Well, the Washington State Patrol used to be called the Washington State Highway Commission. Before that, they were called the Washington Railroad Commission. So when you go look up the original session law Senate bills and House bills for the Railroad Commission and look for their authorities and powers, it says that they only have authority over the common carriers.
Yeah, I don't know what's going on. I got depositions tomorrow and
Well, and
Tuesday
then
on.
you go back
The
to
state
carriers or postal people.
the
So
state
that's
patrol still gets their retirement check from the railroad.
I got depositions tomorrow against two of their troopers. Well, one on Monday and one on Tuesday. Shout
Can I
out. Shout out Attorney General's
Can't
Office of Washington Torts Division.
can't wait, Cam. Hey,
can I
Cam.
throw can I
Can
throw
I
some in here?
go ahead? You go. You go.
Okay, yeah. I keep forgetting how to raise my hand in here, but since first time was in 2000, 2001, I had CDL Class A. Then I got rid of it, got back in it 2019 when I come off disability. So I don't know how many of y'all have had CDLs like the commercial A, B, or C or anything, but and this coincides with uh, Chicago Motor Coach versus City of Chicago. As any load I pick up, and I'm trying to get on it IMI, that's the concrete trucks to actually drive them for profit. But and I hope this clears some things up and it connects some dots. So whether I'm pulling a flatbed, a reefer, a class A, B, or C motor vehicle that is designed to haul more weight and it like your regular pickup truck or so forth. Uh, I think some of the Chrysler vans you put 1,200 pounds in the back, and it's not considered a Class A, B, or C motor vehicle. No guy makes a lot of money like that. So it doesn't matter if I'm hauling high ice, concrete, perishable goods, scrap metal cans. Uh, if I have a destination and an order is created, then I have to go, say, if I get on an IMI and I have to go load this 11 yards of concrete. So I now have a bill of lading. So I take that and I deliver it as commercial use and making a profit while I'm using the roads and stuff. I drop the load of concrete or whatever it is I have off. It could be water, could be air, anything that you can haul, compressed or anything. If I'm, yeah, anything. So when I get destination, they sign that bill of lading, and so that is a commercial use. You have to have an origin of pickup. You have to have bill of lading. You have to have an order, and it's going to be something that you or the company that you're employed by with a contract that is selling for a profit. That is a commercial use, and they have weight restrictions. Like unless you have a special permit, like oversized, uh, I've hauled loads that were almost 120,000 pounds. Uh, uh, there's weight restrictions to basic semis you see, and my biggest argument when it crosses over into CDL, it's like the complete different design of a vehicle other than your automobile, which you push a brake and a fluid hydraulic system. You have hydraulic brakes on your automobile. That's what slows you down and all that. There's no pressure that has to be maintained, nothing like that. But on a class A, B, or C that has air brakes, and there's some that's like I think hydraulic pressure over air or something like that. There's a few stipulations in there. But if you are operating a motor vehicle, hence semi truck, a big van delivery truck that is over a certain weight, the design of that vehicle, air brakes, you have to have a class A, B, or C CDL, a commercial driver's license. That's a fact. There are so many more restrictions, like height restrictions. 13.6 is top of the mountain. You know, we go anything at 13, we're going to be peeling off the top of the truck. And a long time ago, I seen a Pepsi truck, one of the little short day cabs and the little short trailer. He still could weigh 80 pounds by the design of the truck, but he tried to go under underpass. It was 2 foot low, and he opened that little 30-foot trailer up like a pop sardine can. The doors are still attached, laying off the back of the trailer, dragging it around. He rolled it right off. But my point is, a commercial vehicle is a special certain design that has brakes, that is its suspension and braking system is made to apply the pressure by air to stop 40,000 pounds. I mean, 40 ton or 80,000 pounds, however you look at it. And the reason I have to know this so good is because of a lawsuit I'm getting ready to file with my ex employee. But if that helps y'all out, so next time you're next time you're traveling down the road and you look over and you see a semi, the braking system and everything, the suspension is totally different than what your automobile is. And when you travel in an automobile, like I do my Jeep, it's paid off. I am not, there's no order for me to go pick up my own groceries at such and such store to bring back. I mean, I ain't even paying myself, that's a right.
Hey, you know
Yeah.
something? Troy, I don't know if you're seeing this within what you just shared as far as the link is concerned, but it makes me wonder, do you go this route sometimes too, as far as an administrative good faith procedure? Right under the 501 organization and delegation of powers and duties. And I'm sorry, Lewis, that I'm going on a tangent here, just sidetracking, but we're just, this is how
Well, I'm
Wisedome
hoping
does
this will
sometimes.
help his case, because where I'm going with this is we got to get back to the secretary is the one granted authority to do all this, Secretary of Transportation.
Well, check this one. It says the authority is 49 U.S.C. 105 and 322, and the delegations of authority under 49 CFR 181 and 195. And then the source is coming from 2016. When you come down, you're seeing that this part describes the organization of the NHTSA, which is the National Highway Traffic Safety Administration, right? And within 4, there is a director of the Office of Civil Rights, okay? As the principal advisor of the administrator and deputy administrator on all matters pertaining to civil rights, meaning that you can now go down directly to the administrator and then the deputy administrator to also get clarification of matters that you're seeking in relation to which they serve as Director of Equal Employment Opportunity, right, business, and of Title VI compliance, Civil Rights Act of 1964 as amended, and related regulations. Assures agency compliance with Section 504 of the Rehabilitation Act of 1973, the Americans with Disabilities Act, ADA, and other non-discrimination statutes, regulations, executive orders, and policies. Periodically reviews and evaluates the civil rights programs of State Department motor vehicles and highway safety offices. So not just this NHTSA, but also DMVs,
Yeah, and
State
the
Department of Motor Vehicles.
and that all happened in '99 when they created the motor vehicle that other department MF what is it? The one that,
FSA or something like that.
yeah, that one, the Motor Vehicle Association, just like the National
Oh, you're
Highway.
talking about AAMVA?
Yeah, they were both created at the same time, but at that point they said anybody that gets federal funding is bound by all the rules. It means everybody's bound by Title 41, 49, and the definitions in Title 49.
So check it. There's something you want to get that might be pretty heavy hitting, right? On these internal things that have gone and done their due diligence and they're part of the whole structured program. If you're going to the director, according to what Troy has showed us, of the NHTSA, as well as the administrator under the office of the administrator and the deputy administrator, top dog's director though, right? They're going to be periodically reviewing and evaluating the civil rights programs of the State Department of the Motor Vehicles and Highway Safety offices to ensure that recipients of NHTSA financial assistance meet applicable federal civil rights requirements. Are they or are they breaking them? Monitors the implementation of and compliance with civil rights requirements. Are they going to just say, oh, it's on the business side of things? Investigates complaints of discrimination. Is that just for application, or is that also for the application of commercial regulations against one when one has not entered the system? Conducts compliance reviews, meaning are they complying with everything that they have as a base to comply on said rights? Provides technical assistance of recipients to the, again, provides, NHTSA financial assistance and stakeholders. What do you mean stakeholders now? Who's getting a profit off of this? I thought this was a governmental agency here. And provides assistance to the office of the secretary in investigating and adjudicating formal complaints of discrimination. Well, if they're the ones that's supposed to be overseeing the State Department of Motor Vehicles and the highway safety offices, or the NHTSA, that again is kind of in alignment with AAMVA, and I would think you would be able to get some kind of assistance and or possible answers from said deputy administrators and or office administrators and the director of the Office of Civil Rights, just as much as you could reach out to the Department of Justice in your state, as well as far as the Civil Rights Division is concerned. And again, these are the ways that you would say, listen, I know that I have a right to travel. I know that this is a given right. I would like to establish some certain violation and how these things are applying. Get the paperwork, get your documents, get anything and whatever you can from their system to utilize that good faith aspect here. And bro, yeah, if you want to start trying to do some good faith here as far as any violations that have occurred to you, this might be a good place to start, according to Troy, and what you finding out in relation to the director on the Office of
To
Civil
put in
Rights.
the civil rights deal in there on title, it's for the Motor Carrier Safety Administration, Department of Transportation.
You know what?
That's 49 CFR 303 and the Civil Rights Act under that, where it says everybody's bound by the Civil Rights Act. So,
Chris, I would say this would actually really apply to your situation, bro, and what you're going through with your employment right now as well.
Hey, I was going to say something. Yeah, in the state of Florida, I found this out because I got a Class A CDL. When you got a medical card that you have to get done every year for you to be commercial,
Right.
and I went in, I went up there and I was like, I forgot to renew my medical card, so they had they didn't. I get not cancel, not revoke. There was another word they used, and it wasn't suspended. It was weird. So I went up there and asked the DMV what was going on with my license, and I said, "Look, I said I'm self-employed. I said, but I don't really use this in a commercial aspect." And she said, "Okay, well you can waive the medical examination for the medical card." And I said, "Really?" I said, "Let me see the document." And there's a form, and I'm sure it's like this in other states too, where you can fill it out, and it's a farm use non-commercial CDL. As crazy as that sounds, I've got one. It's a Class A farm use non-commercial CDL. So when you waive the medical card, you're really out of commerce at that point.
Right.
You know.
And now these states
Question is that used for your farmland and like your private land only?
Yeah.
Because
yes,
that's what that applies to. Because I live in Florida and I was trying to figure out a different way to establish my right to travel. and I
Yeah.
came across that, and it applies directly to if it's like farm related on your property, as long as it's not on a public road, then it applies, that exemption applies there, but it doesn't apply when you get on the road.
Cam, can you
No,
put
you
that
could
link in the chat? What you're sharing?
under
I put
agriculture,
it in there.
you can put
Thank
all
you.
you can haul all kind of stuff agriculturally. The problem is, and this is how I even learned this from a state trooper. He told me, obviously, if you've got a manifest and you've got a bill of lading, well, that's commercial. Like,
Right.
to me, I don't make it like I sell a lot of firewood, but I sell it commercially. You understand what I'm saying? But nobody
Right.
knows that it's my property until I take it off. So I never write an invoice while I'm in transit. Does that make sense? So
Yeah. And
it's your
there's another
property
guy.
while you're transporting it.
Right. There's another guy that did it a really slick way. He had like a 16 or 18-foot pull behind trailer, one of them enclosed trailers, and he would privately talk to people and say, "Hey, we need this or we need that." So to cut out the middleman, he would go buy, pay for, or acquire himself and load the trailer like food or whatever, and then it was paid for. So anything, I think it's under U.C.C. Anything that's completely paid for, it takes it out of commerce and puts it into household good. So then he would travel, and they would come to him, or he would go to them, and they would talk, and then they would purchase the stuff out of his trailer, his personal stuff, which there's no law against. So that's how he got around commerce and everything. It was a pretty neat thing.
Yeah,
When you
a state
sign
trooper
up,
told me.
when you sign up for the DOT, it asks you all of those questions, like what you're hauling, and based on how the system has it set up, if you answer the question wrong, it won't even offer you the non-commercial, non-DOT.
No, we get
The
that,
DOT,
bro.
yeah, it won't even offer it to you.
No, yeah, we get that. That's not. It's not about applying for it. It's that the officers don't respect it, bro. That's what's going on with the DOT.
Yeah, they're
These
brainwashed.
we've literally had maybe in the past year we've had like 20 of them, bro, using DOTs, and I would say one out of all of those that have come to me have not been arrested for the DOT. Like they get arrested for it, bro. So I'm not saying that you can't get the DOT and that you could try and argue that way of it. You can go that way. I know my boy's been doing it, and when it comes down to it, like Sean in Arizona, he was pretty much arguing the aspect that even the cop in the evidentiary, or no, it was in trial, ended up stating, the plaintiffs, the state asked the officer, he goes, well, do you have any eligibility to look up the DOT plates? And dude said no. He don't even have eligibility to look in the safer system if the DOT was valid or not. And it's because they don't be I mean, I guess like Lewis was saying earlier, it's all based on how much you bring forward as far as knowing is concerned, right? That they'll start to treat you different in some form or fashion. But when it comes down to it, like 90% of the people who have had DOTs are literally getting fictitious plates, forgery, and they're getting arrested.
You get you get a specific plate. It's called a Z plate. If I am correct on this, I'm only mentioning all of this because, like I said, I'm trying to be thorough. I haven't done anything with it. I have it, but I haven't used it. So I'm only asking these questions, and I am getting a lot of good insight off of what you're telling me. So yeah, I'm just trying to learn. I'm just trying to figure
Where's
out.
Sarah at? Is Sarah still in here?
I have a way to reduce the amount of arrests for those things. Okay, so all you folks need to look to your criminal code. There's two statutes. There's an arrest with warrant statute and an arrest without a warrant statute. So you need to get a copy of both of those statutes in your criminal code. Arrest with a warrant, arrest without a warrant. And then you have to go to your motor vehicle code. It's going to have a traffic arrest statute. Okay, so I specifically have a flyer that defeats that, which cites in Washington RCW 1031-100. Okay, the arrest without warrant statute, and it used to only have 3 subsections. They've amended it because of me, but it now has 16 subsections. But RCW 1031-100, subsection 2A, B, and C list every statutory offense which a police officer has the authority to arrest and take you into custody. And it uses those words, and take into custody. 462342, driving while suspended, is not included in that subsection. It used to be in subsection 3, but now it's down in subsection 16 where it says may arrest, but does not use the word and take into custody. And that was noted by a case here in Washington called State versus Stortron, 53 Washington Appellate, page 654 in 1989. That appellate case was reaffirmed by our Washington State Supreme Court in a case called State versus Redding, where they reaffirmed State versus Stortron, but they said, hey, this is a traffic stop, so we can't use the General Criminal Code Title 10. We have to look to the Motor Vehicle Code Title 46 and its arrest statutes, 46-64015. And they noted that that statute doesn't provide any wording or language to the fact that a police officer can take you to a full-blown custodial arrest. It says they may stop you no longer than reasonably necessary that it takes to issue a citation and notice to appear. And then they cited a Ninth Circuit case that says police officers may not arrest people for minor offenses. And so basically they have to let you go. And sometimes you get a cop will say, well, I still have to give you a ticket for the reason I pulled you over. It's our policy. So I even put in my flyer, it's like, I got a flyer for each little thing, you know. State versus McIntosh. It says issuance of a citation after arrest for a traffic misdemeanor is discretionary with the arresting officer. Whenever any person is arrested for any violation of the traffic laws or regulations, which is punishable as a misdemeanor or by imposition of a fine, the arresting officer may serve upon him a traffic citation and notice to appear in court. State versus McIntosh, 42 Washington Appellate, page 573, 1986. This means the cop has the discretion not to give you a ticket even after he's arrested you. And I got the case law that says you're under arrest when the lights come on. But there's a difference between an arrest when the lights come on versus a custodial arrest. And they can only search your car incident to a lawful custodial arrest. What that means, they can't search your car unless what they pulled you over for is actually an arrestable offense. If it's only a civil infraction, they can only issue you a citation and notice to appear. And the court rules in Washington State say the same thing. CRRLJ 2.1b, citation and notice to appear. Issuance. Whenever a person is arrested or could have been arrested pursuant to a statute for a violation of law, which is punishable as a misdemeanor or gross misdemeanor, the arresting officer or any other authorized peace officer may serve upon the person a citation and notice to appear. And I have a case that backs it up. Torres versus the city of Anacortes. An arrest for a misdemeanor or gross misdemeanor is not.
Uh-oh. Hold up. You're muted. You're muted, Lewis.
That must have been an accident.
Yep. Okay, go ahead.
So did you guys hear State versus McIntosh?
No.
Yep.
Okay, so what I was saying, did you hear State versus Stortron or State versus Redding?
We heard the Dorchin.
Okay.
I thought I did.
You were only on for about 10 seconds, bro. Yeah.
Oh, okay. Sorry. I don't know how that happened. I didn't even touch anything. Somebody doesn't like what we're doing.
If you hit the space bar, it'll do it.
So I think someone's
sometimes.
trying to shut you off.
Oh, I might have touched the space bar. Okay, sorry. Yeah. So in Washington State, we have a arrest without warrant statute.
Right.
Okay, 1031-100.
Yep.
Subsection 2A, B, and C list every statutory offense for which you could be arrested and taken into custody.
Yep.
It does not include driving while suspended, 462342. It used to be in subsection 3, but now it's in subsection 16, and it uses the words may arrest, but does not use the word and take into custody, as does subsection 2. So this was cited in our appellate court, State versus Stortron, 53 Washington Appellate, page 654, or 769 Pacific Reporter 2nd, page 321 at March 20, 1989. So they specifically held in State versus Stortron that people cannot be arrested or taken into custody for driving while suspended in the state of Washington. In my flyer, I call it my stop arrest flyer. I also cite State versus Redding, our Washington State Supreme Court, which not only reaffirmed State versus Stortron, but they went further and said, hey, this is a traffic stop. We can't use Title 10, the General Criminal Code. we have to use Title 46, the Motor Vehicle Code, and look to its arrest statutes, 4664-015. And the Supreme Court of Washington specifically noted that there's no wording, no language to the fact that an officer could take somebody into a full-blown custodial arrest. It merely provides that the officer can stop you no longer than reasonably necessary that it takes to issue a citation and notice to appear. And then it cites a Ninth Circuit case saying the same thing. Cops can't arrest you for a minor offense. And when you run into a cop that says, well, I still have to give you a ticket for the reason I pulled you over. Well, this flyer also contains a case called State versus McIntosh, which says issuance of a citation after arrest for a traffic misdemeanor is discretionary with the arresting officer. Whenever any person is arrested for any violation of the traffic laws or regulations, which is punishable as a misdemeanor or by imposition of a fine, the arresting officer may serve upon him a traffic citation and notice to appear in court. State versus McIntosh, 42 Washington Appellate, page 573, or 712 Pacific Reporter 2nd, page 319, January 13, 1986. Even our court rules. I like to do a complete wrap when I do something. I put the statute, I put the court rule, and I put the case law that says the same thing, and I basically kick their ass with this. People are handing my stop arrest flyer, which I consider the most important one. They're handing this stop arrest flyer to cops in real life traffic stops, and they're being allowed to drive away from a real life traffic stop. It's only one time since in the last 25 something years where I had a guy in the city of Fife called me at like 3 in the morning crying, told me it's the first time he's never been arrested for driving while suspended. His wife threatened to divorce him if he went to jail one more time. And he was really happy he didn't go to jail, but he told me his car got impounded because the cop said he's not going to let him drive away or wait till he leaves to drive away. So he towed his car because he didn't have a license. But the guy didn't go to jail. This flyer will save your ass from going to jail. And I guarantee you, every single state has an arrest with a warrant statute, an arrest without a warrant statute, and then you go to your motor vehicle code, it has a traffic arrest statute. If you compare those three statutes, you are going to find out they can't take you into custody for driving while suspended or driving without a license. They can't do it unless you have a record of failing to appear. That's the problem for a lot of people.
Well, you did on your when you came through on your arrest without a warrant. You was really accurate, even on 16A. The only thing I would probably go into a little bit more on 16A is when you say that the officer shall arrest or keep in custody. You got to remember it's on two specific statutes, right? One that you're driving under the influence, and then secondarily, it would be physical control of the vehicle while under the influence. So it would have to be really, truly a crime. And the only aspect of how they can make an arrest without a warrant, in all actuality, is for those as well, right? Now, if you had something that come down to relating while suspended or revoked or relating to operating in a negligent manner, again, you're getting more into the aspects of, first off, contractual agreement that you've signed, and or secondary that you pose some kind of safety risk to the other. That's what I mean. Negligent manner would essentially.
And there's
Okay,
also
look at three. Look at three. Any police officer having probable cause to believe that a person has committed or is committing a violation of any of the following traffic laws shall have the authority to arrest the person. It does not use the words "and take into custody" like subsection 2 does.
What's the difference?
One says they can arrest and take you into custody. The other one says they may arrest you. Okay, you're under arrest when the lights come on.
Okay.
And there's
Can
also
you
a
throw
very
up the flyer?
specific list of codes they can use also. So, and that's an inclusive list. So they can't expand on that list either.
Now, check this out. In State versus Georgia, it says the difference cannot be deemed inadvertent. The omission of words from a statute must be considered intentional on the part of the legislature. And they were talking about that and taking the custody part.
Yes, but wait, Louis, what doctrine is that we use it? No, Wisedome, don't say nothing. What doctrine is that you're utilizing then?
You can't read words into a statute that aren't there. Expressios est unios est excludio.
Exclusius authorities. Yes. What doctrine though? It's rule of lenity, bro. Rule of lenity, bro. Lenity.
Hold on a second.
It's lenity, bro. It's lenity. It's lenity. Rule of lenity. That's the doctrine.
Yes, the rule of lenity. That There's another word too that talks about crimes versus mala in se versus mala prohibitum, which goes together with the rule of lenity.
Yep, that's keeping the statute very narrowly, right? Statutory interpretation in criminal law requires courts, okay, rules of strict construction that when a law is unclear or ambiguous, you know, that void for vagueness doctrine that we can utilize in conjunction with, the court
And
should apply it.
Yeah, I use the overbreadth doctrine, the void for vagueness doctrine, and equal protection of the law, kind of all
This one
go
hits
together
too
with the
because
void
look
for
what it say.
vagueness.
Look what it say. The court look when it's clear or unambiguous, which is this is made very clear. Okay, when you're speaking of arrest without a warrant, it is very clear, my boy. So if they try to reach out in any way and try to misconstrue what the statute is saying, the rule of lenity would apply. And what is the court should apply it in the way that is most favorable to the defendant.
Can I drop some of my flyers in your box? I didn't
Yeah,
even
come
see
on,
that.
bro. Yeah, because I put text too, but yeah, I gave you access, the one you just asked for right now.
Yeah, man, drop them in there for sure.
Okay.
Hey, while he's dropping them in there, can
screen
I?
sharing? No, I want to add the How do you the chat? The chat. I should be able to drop the
Now,
flyer.
also, Danny, you
Thank
can
you,
throw in.
Lewis.
You can, Danny. I want Danny to come through and make a statement. He's trying to make a statement. One other thing I want to bring in the rest of this rule of lenity is check this. We're kind of moving ourselves out again. Another argument outside of the statutory framework and body of law, in which the state is in court is trying to make their first presumption on, right? Remember, you got to rebut that shit. That's why I come through with that PDF and dropped it in the chat, because you really got to rebut that shit. They got all these presumptions and assumptions that they're coming in with, like Jeremy was making a point of mentioning as well, that you gotta rebut. How you gonna rebut that? Again, your documents that you're bringing forth, and the things that you're using as far as doctrines are concerned, principles used in criminal law, especially if they're using a DWLS. Okay, because the rule of lenity stems from two constitutional objectives. First, the separation of powers, like we always talk about. It's literally dictated right here. The separation of powers, the Commerce Clause, all that shit y'all talking about, right? It's established in the rule of lenity, bro. You just have to invoke that motherfucker. You have to invoke it.
I got something funny for you, Cameron.
Yeah.
I have an Indians' Rights to Travel flyer. Now, the flyer doesn't contain this, but if you pull the sites that are in my Indian Rights to Travel flyer, it says the Indian has the same rights as the white man to travel on a public highway without a driver's license. And I'm like, when did the white man ever have rights? How come the Indian have a right to travel?
Oh, that's funny. Otherwise, they don't. Otherwise.
So what I wanted to bring
if you guys have any Native American Indian friends, you give them my Indian Right to Travel flyer. They're going to be buying you beer tonight.
Oh yeah, hey, I got a bunch, man.
Hey,
me and the tribe's having all kinds of fun down here.
Hey, Danny, go ahead.
Yeah. What I wanted to bring in for Lewis and for everyone here is, I mean, it's the same thing that I often do bring up when we first get hauled in. So we get the dang ticket, whether they let us drive off or not. We still have that moment where we have to show up at court or we'll be arrested, right, under threat of arrest. They'll issue a bench warrant or something and mess up their life. So at the first appearance, the first moment that you show up there is this whole aspect of declaring your special appearance for lack of jurisdiction, demanding that the prosecution put their evidence of their jurisdiction and their standing to even have me there, put it on the open record, to swear in under oath, give their name and place on the public record what is it that they say that they even have jurisdiction to have me there. People say, oh, that's hard to work. That's hard to work. But if you land there at the very moment of, this is my special appearance, Judge, and I take this sanctity of the special appearance very seriously, I'm raising a constitutional question. We have a problem that statutes must be left void for vagueness if this man cannot show that he had standing to even bring me here in the first place. And very often the judge or someone will attempt to railroad, Mr. Edwards, we have, you live in Long Meadow, Massachusetts. And my whole premise on all of this is, whoa, 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 Judge, I don't know if you're attempting to enter a fact on this record, but I've showed up special appearance. I can't hear statements until the prosecution show. Burritz's thing on the thing, my special appearance is paramount now because I'm challenging this jurisdiction. And so we can't really move forward, and they try to railroad you. Maybe they'll even yell and bark. And as soon as they really start talking about, do you understand we have this role? And do you understand? Whoa, whoa, whoa. I do not understand, Judge. In fact, I can't hear you. I'm on this side of a special appearance, and apparently someone else is attempting to enter facts. Please have prosecution swear in. What's wrong with this approach? Because they can't prove my residency. Well, Mr. Edwards, don't you live on 1650 Long Meadow Street? Excuse me, I'm here on this side of special appearance. If you require me to answer a question so that you can gain jurisdiction, it means you don't have jurisdiction. You don't have standing to bring me here. All elements of standing must be demonstrated here, open in this public court. And I know they're going to say this is private. I've heard them say that to me before. No one gave me notice of private. I have a Sixth Amendment right to not only speedy, but public proceedings. So no one gave me notice if there's anything other than public proceedings that would be my constitutionally protected right. I raised the constitutional questions. I have a problem, and Judge, I can't hear you if you keep attempting to enter facts onto the record.
Right.
I might
What do you
require
want
you to
to?
recuse yourself.
Well, what do you want to do then at that point? Again, you're right
At
about that
that
because
point, I
there
want
is
to watch them. I want to watch them not be able to
worm.
say you're a resident, not be able to say you're a licensee, not be able to show any
Okay, now
nexus
check it.
between me.
Now check it. That's great bringing it orally, right? But where is that going to be at in relation to the process of the claim that they are bringing forth under the jurisdiction that they are claiming? They're claiming they have a jurisdiction as far as subject matter. They're wanting to say they have one as far as the locale is concerned, so personal, all under the Commerce Clause. So what do you want to bring
Yep.
forth? You want to bring forth a judicial memorandum of law, in fact, in support of the right to travel of locomotion and private travel. That way that you have something on the record. Then if you're doing it orally, you got to get those transcripts, because if you don't get those transcripts and object to any presumptions that the court is making upon you, then where are you going? Right? You can't get no
Well,
appeals if you
those
don't have a
objections.
record. Now
That's
that's a
all
big.
true, Cam.
Yep. Now there's also one thing that's also pretty interesting that I just posted this last week in the general chat, and that was in regards to California's aspect of putting a record that can be constantly always in place at all times in relation to California, even down to the municipal courts. It's in this California deprives millions of constitutional rights, right? And Father of Exile. I'll repost it in the general chat again, copy text. We'll put it back into the general chat of Discord. But this is very interesting and something that just was uploaded, I think, this week. In relation to some conversations that they're having with justices in relation to building a court of record, even within the municipal courts, and making sure that everyone has that right to take up to the appellate court in California itself, and how it's a big problem, whether they're utilizing AI technology, whether they're hiring court reporters and making sure that those court reporters show up in all regards, but that everyone has a constitutional right to a court of record, to a court of record. Thereby, in almost a certain instance, you could say, once they implement that, hey, I'm not getting my court of record, right? Which is a constitutional right. So any kind of administrative municipal courts that are stating they're not a court of record will establish, are they a court of record up front? And if they are not, we need to move it up to a court of record. So therefore, I'm going to be, right? I mean, there's
Absolutely, Cameron. And all this would, I mean, so very first thing, there's always some time in between the ticket and the time in court. And that's when you literally send in everything you're going to say, stating your special appearance so that they can have on record your memorandum and your affidavit in support of, along with that you're there on that you're being forced to be there under, and so it's under a special appearance. And at that point in time, when they try and say, we don't have this, or I barely saw your thing, I perused it, and they try and act like they don't have stuff, it doesn't, at that point in time, that's where the challenge, it's always on the first one. So if they railroad you on the first one, you maintain that special appearance for the second one.
well, what are
Between
you
one
going to
and
do as
two,
far as, well, what are you going to ask for then? What are you going to ask for? If
I'm
they're,
demand dismissal. I'm going to demand
yeah,
dismissal with prejudice. And
you can do that. Or what if the court says, well, we're not going to hear this at this setting at this time? What are you going to invoke? What are you going to ask for? Or what are you going to
say it
demand or
again, Cam.
request?
We're not
Let's
going
say
to
that you
do.
go in and you start orally arguing some things out, right? And they're saying, well, we're not going to listen to this matter at this point. What are you going to request or demand and ask for?
Well, I can't hear you, Judge, because I'm on this side of a special appearance before any kind of jurisdiction was handed. So I can't hear you because they're going to need me to acquiesce somewhere. And I can't hear you, is my
Okay.
words to anyone saying something.
Okay, cool. You could do that,
That's,
or you could ask for a motions hearing or notice and demand hearing, right? And what are we
I
going to
would
be
want to
doing?
exhaust that before I do any motion stuff.
Well,
I would
let's
want to
just say you're
exhaust the
bringing
crap
in.
out of that. But
Okay, cool. But let's just say
go
that
ahead.
some people are not as versed as you, right? And they need to go through this process, and they can't stand as strong as you because they don't have that impact. That they don't have the knowledge and wisdom that you have to make the standing like you do, right? You want to put something on the record, bro, of the judicial memorandum of law, judicial. And it's got to be in fact in support of. It's just like I was speaking of to Joey Kimbrough this morning, okay, before we started. Joey was kind of mentioning, Brandon had made a post, and I'm like, well, we be getting evidentiary hearings, and we be getting motions in limine granted. And they're kind of like, well, the 14th Amendment Joey's kind of like, the 14th Amendment will surely get you, into a sovereign citizen category, being ignored, right? And I agree with them in certain aspects, but again, the creator endowed rights and the like Lewis is bringing forth is the statutory argument in relation to constitutional rights because you need to have those points and authorities or the memorandum, and it must be in support of whether it's your affidavit that's bringing forth all of your reservation of rights, including said special appearance, right? You got to work in their kind of process. You don't want to buck the system too much to where they just start throwing you a category where they ain't listening. Kind of work within their framework and process, and that's where you're gonna get some remedy rather than uh the frivolous aspect of what Lewis has been mentioning in relation to the sovereign citizen category of what's known today, which literally is just frivolous. Really? That's all it really is. Get outside of the frivolous and start applying the actuatory, statutory, or constitutional framework with the judicial memorandum in support of, with points and authorities in some regard. Then you start really getting then you really start getting some differences in relation to how they are going to speak with you. Now, they may not argue with you in that initial appearance in that regard. This is just an arraignment, my good sir. All right, well, we're going to bring forth a notice of hearing at least I am going to bring forth a notice of hearing in some form or fashion to get this brought forth and argued out. And if the state ain't responding to what I'm bringing forth, affidavit in support of with a judicial memorandum, right, in support of, okay, then what do we get? We start getting a secondary aspect of violations, the failure to respond, the failure to prosecute, right, prosecutorial misconduct. Why do we have misconduct? Well, because I can't even understand the state's theory as far as other than the citation that's been brought forth. And Your Honor, they're failing to prosecute in any form or fashion the claim that they are bringing forth, and they fail to answer my rebuttals. So we need some kind of hearing, bro. Whether it's a motions hearing, a notice and demand hearing, however they want to title that bad boy, whether it's a suppression hearing or an evidentiary hearing. Suppression hearing is going to be a lot, more fine tuned to just suppress evidence versus an evidentiary hearing, which is, do they even have standing to really bring forth this claim that's against me? But you want to get it in. It's like me. I'm always getting it into the aspect of, okay, what forum do y'all want me to utilize to get in here and bring forth the arguments that I need to bring forth? Because no matter what, they're constitutional violations, and all constitutional violations are first and foremost before any statutory claim can be brought forth. Because again, the
Agree.
bottom of the barrel or the foundation of it all is, do you have the constitutional authority at this said claim that you're bringing forth if things have not been put in alignment, such as
Uh,
contract?
I totally agree with that, Cam. Like all of that. And if the railroading continues and you're now been thrown in jail for half a day because of contempt and they're really like trying to rain down on you really hard, then, I mean, for me, then of course I end up doing that stuff. If I'm not sure about how to stand with that, or if something goes awry, you have to be ready to do everything you just said. My whole thing was I was just sort of trying to get from Lewis. I sort of just framed out basically how to stand in the very first moments, because you're not there until you show up. The court has nothing to do with you until you're physically there for that very first moment, very first words and all of that. And so I was wondering from Lewis, what did he think about that? I can't hear you. Place your standing, special appearance. No, I can't hear you. I can't answer. Please don't place facts on the record. Please recuse yourself. Judicial notice prior of facts, impartial only. judicial notice, I'm due deference, I'm not a bar lawyer, all the stuff. You state as soon as they try and talk. And Lewis, what do you think of that method of like trying to end it on in moments one or moments two? Moments one being the show cause, or if they have some kind of probable cause hearing, that guy will probably railroad you and push you forward like my fat face guy did, regardless. But the second guy, he didn't want to deal. He did not want to deal, and I don't blame him
Well,
because I was there on a special appearance.
Here's the biggest thing that most beginning pro se litigants make is they trip you up on procedure.
Yep.
So you show up to court at their hearing. That's their hearing. They
Yep.
scheduled it for whatever purpose it might be. It could be your arraignment, and you're trying to argue all this constitutional stuff or common law stuff. The judge is going to say, I'm just here to enter a plea. You'll plead guilty or not guilty. They're like robots. They're not going to hear
I can't
anything
hear
else.
you, Judge. We've moved past my right to have special appearance and to have their standing placed on the record. I still don't hear from the prosecution. So I think you're trying to say something, but I still can't hear you because I
Let
haven't
him finish,
passed beyond.
Danny. I know you're.
I'm getting to that. I'm getting to that. It's their hearing. So if you want to make a particular argument in their framework of following court rules so that they will listen to you, you have to serve the other party, whatever document or argument you're making. You have to file a proof of service. Then you file another document called a note for motion or note for motion document, and it'll say note for motion up in the main header underneath the case number. It'll say an issue of law will be heard on Thursday at 1:30 p.m. And then in parentheses, it'll say clerk's action required. And then down in the main body of the document, the defendant notes the following motions for hearing. Number one, standing or jurisdiction. You put, most defendant appears by special appearance and not generally pursuant to RCW. I think it's 4.28010. I'm not sure in Washington. We have a special appearance statute here in Washington. The only purpose for making a special appearance is to challenge the jurisdiction of the court. If you go into the merits of the case at all, you just waive special visitation.
Agreed.
And you just acknowledge to the general jurisdiction. So you got to have something upon which to show that they would have no authority to write you that ticket or whatnot. Now, here's a case that kind of defines a different version of jurisdiction that you guys probably won't like or won't accept. The city of Orting versus Rushner. The city of Orting versus Rushner in Washington State basically says the jurisdiction of the court is established by the police officer filing the citation with the court. Whatever the charge is, drunk driving, running a red light, the jurisdiction of the court is conferred by him filing the complaint with the court. That's how they claim they have jurisdiction, because that goes back to the city of Seattle-Filson. The courts of a limited jurisdiction, the municipal courts, district courts, only have the jurisdiction conferred by a statute. There has to be a violation of a statute. The cop is the state's witness. He's filed a complaint. They have jurisdiction. Not you can't go into court and say, Your Honor, the court has no jurisdiction and just make a blanket claim. How is it they have no jurisdiction over you? It's not because you're the living, breathing man, or singing the song, I'm a beautiful woman. It has to be a legitimate reason why they have no jurisdiction, not because you're a state national. That's a bunch of nonsense. Oh, I got to tell you guys something funny. People ask me, what's the difference between a sovereign citizen and a state national? And I'm just trying to be funny here. Okay. There's Cameron and my definition of sovereign that back in the day, it's supposed to be, it was a respectable thing to be. Yeah. But the cops, they label anybody who's a government resistor as a dumbass sovereign citizen, somebody who doesn't know the law. They're fucking know-it-all. They're quoting statute, court rules, and case law, but they're misquoting them out of context because they never did the research themselves. Okay. Now, what is the difference between a sovereign citizen and a state national? Well, the state national, they don't want to be classified as a sovereign citizen because they know the cops think that you're a dumbass if you're a sovereign citizen. They say, oh, no, I'm not sovereign citizen. I'm smarter than the average bear. I'm Boo Boo Bear, not like Yogi Bear. Okay. So to me, the category of a state national is kind of like the difference between an autistic person versus a person with Down syndrome and a different level of retardation. So to me, the state national is a special kind of stupid.
This guy.
I prefer just to be an American.
Me too. Troy, read that for us real quick. What is the duty to be an American, my brother?
I am an American as a challenge to the highest ideals and aspirations of mankind, to self-sacrifice and devotion to the loyalty and the patriotism, to joyful and work and courageous achievements, to magnanimity and charity to all, and malice to none, as we seek to uphold and perpetuate the principles of our great republic.
Bro,
Yeah,
that's
that's what
that's
we are.
that's deep, bro. That's
Damn.
what I want to be. I want to be an American. I don't want to be. I don't.
This
Yeah.
this is the only law I follow.
Mm,
God's law.
you dig?
This is the law I follow. God's law. This
Yep.
is the 1599 Geneva Bible.
Yep,
Yep.
that's what we follow.
Yep.
Absolutely. Our rights are given to us by our Creator, and we must live great souled and demand the same in return.
Any of you guys study the Bible?
Yeah, that's where law comes from. Deuteronomy, good one.
Leviticus 19:13, thou shalt not defraud thy neighbor. I put that in my administrative documents I send out.
For real. That's what it's
Well,
about, bro.
I'll give you a few more Bible quotes. The woman might not like some of my flyers.
So please don't do it on Operation Wisedome, bro.
Woman, man.
Later, I guess privately.
Laws of I write scriptural flyers too. So there's laws of marriage with all the scriptures about what a man and a wife are supposed to do in a marriage, and I also have laws for children.
As we should. There's no doubt about it. As we should.
Yeah, we should. And all those come from all that stuff's written in the Bible too, man.
Yeah.
They got prayer instructions.
There are some arguments about what Bible should be. Like some people are specific on like 1584 Geneva, whatever. Do you think any of that is important, or is it kind of just nonsense?
Okay,
Well,
now in what context and in what
people
setting?
ask the difference between the King James Bible and the 1599 Geneva Bible. Okay, King James Bible was a Bible written for slaves. It's the most commonly used Bible because it's the latest version that was written in English. So that's why more people use the King James Bible than other Bibles. But the 1599 has been recently translated into a better version of English than it used to be. And there's also a 1560 Geneva Bible. The difference between the King James Bible and the Geneva Bible, and the main thing is King James took all the footnotes out of the Geneva Bible. The King James Bible doesn't have the footnotes that explains to you what the verses mean. And also, he elevated the status of man from Luke to St. Luke and Matthew to St. Matthew, which violates the last page of Revelation that says you're not supposed to add or subtract any words from the Bible, otherwise you will be removed from the book of life.
I mastered the psychology of religion out of University of South Florida. King James was a demonologist who wrote demonologies 5 years before he had 47 scholars strip the Bible of over 55 books and forbid him and call him heretic to the whole entire world. And
now one must understand also the context of demon, or what has been translated from
that was another part. That's also a misconstrued thing because the true origin of demon is basically polar opposite of what it's told, just like as anything else. But also Christianity was turned into an institutional version, which is taught in African history before 1850, before the Atlantic slave trade, by Dr. Edward Kissy of the African government, who is a professor at U.S.F. That it was created by the Europeans in the late 16th century off of Judaism in order to colonize, use it as a tool to colonize and exploit the Africans, which originally was turned into an institutional version off of Ifa or Spiritism, off the Blue Nubian Africans way back when, all the way back in 325 AD in the Council of Nicaea by Constantine. That's where all of that derives from.
Yeah, I mean, there is some validity there, but again, in ancient literature, and I'm only utilizing AI because I don't want to go into a whole bunch of searching into my depths of history and understanding how things have just been changed over time. But in ancient literature, a daemon, okay, almost like your demon, you're just eliminating the A, Okay, refers to an invisible, supernatural intermediary between gods and mortals, often acting as a personal guide, spirit, or an expression of divine power. Okay, so a lot of the things get
They were
intermixed.
knowledge gifting.
Yeah, from demons, from the ancient literature as far as a daemon is concerned. There is some really fucked up shit when we study history. All right. Um, Black
Hey,
people
look,
wasn't even started getting called black till recently. It was literally swarthy, ruddy. It was all kinds of actual descriptions, and like swarthy wasn't even spelled with an S. It was spelled with an F in Old
oh,
English.
even when it comes to slavery, racism didn't exist until America was already foundational and far gone into play because it was an invention. It didn't exist.
Well,
Yeah,
where can you find a race that's black or white on the planet? Those were invented by man to classify people under their rule.
yeah. You get some of the oldest
You know,
dictionaries. You start
when
looking.
it
Hold on. You start looking at. You get into the older dictionaries. You start looking at the definition of nigger, bro. It literally says, bro, especially in American Indian. I'll pull it up and show everybody right now.
Yeah,
So
I've seen that. Yeah, I've seen that
in,
before.
in
wild.
different versions of the Bible, I take a verse like out of the Old Testament, Numbers 31, 17, 18. Go kill all women who lay with men, but go keep all children, virgin girls to yourself and have your way with them. You know, how do you go about those laws?
Mm, I think it's all about morality and integrity. That's first off. So you have to look at the morale of things.
Well, and you also got to remember the teachings of the Garden of Eden and where you approach the book of knowledge or the tree of knowledge. You know, it's what's in your heart
Yeah,
when you bring in any content, how you interpret that and bring it forward into your life.
yeah,
And if you do it, yeah, you can bring it toward the light or you can bring it toward the dark. You just gotta be careful which way you go on that.
I mean, just check it out. There's a lot of this white and black and things of the day, but literally looking at, 1843 bringing in 2A of the definition of nigger, bro. It usually says used of any other non-white person, especially an American Indian. I think we need to start really recognizing just how far away we've come from understanding the truth.
Yeah, the language, man. The
The
language.
whole
Like
African
gay.
slave
Gay was never
trade,
in the Bible.
the
Ever.
whole African slave trade and everything like that. Like, why do you think they said nigger camps? Well, because that's kind of the same thing as what they did in relation to when they were calling, the Jewish camps. They were rallying up people who were indigenous already to this land, right? And then through education and schooling, the K through 12, over all of these decades, they've literally taught people that they come from Africa. That is furthest from the truth, bro, that I can tell you right now through sound, deep research, bro. Like 10 years in this bad boy as far as research is concerned. So it has to get to the point of really just like there's so many different overlays that we got to kind of take off of us, and really start understanding that there's a lot that we have yet to learn, you know? So,
Well, there is a truth that in African history that's taught that it is the true cradle of humanity. Everyone alive right now at this second is directly related to a group of Africans. Everyone who is not minority of any kind is directly related to a group of Africans who migrated 200
that's
generations ago.
that's the
And the
dissuade
Chinese
you.
were the
Wait,
ones to prove it.
that's to dissuade you though. That's to dissuade you of the truth that America is the first land to rise from the depths of the ocean, my boy. Like if you want to learn more about things like that,
You
you
mean
should.
like in an Atlantis way?
America is Atlantis,
Or
100%.
Tartaria?
Well, I don't know about Tartaria. I'm talking about literally Atlantis. So it's always been known for a
Oh,
long
yeah.
time. Like I got my hold on, I've got my
Atlantis,
history.
Sparta.
I've got my history channel, right, which I haven't been working on for quite a long time now, about almost 2 years. But I go into the like deepest of the deepest, bro.
And I'll vouch for that too, man. His history channel is above all.
It's deep, bro. Like if you want to get into massive depths of history, you got to come over here with me and the team of researchers that's done
I
things.
need it. I want to see that channel you got.
Yeah, it's Thalato Machi. I'll share the link, but when it comes down to it, like they knew, and it wasn't until about the late 1800s that they started, the
Hey,
World Fairs and stuff
hey,
like that.
Cameron, have you seen the picture of President Trump with those Venusians wearing red robes? They're like albinos with blonde hair.
I've heard someone put that out. I can't
Okay, guess what?
validate
It's
it.
not no aliens from another planet. There's a Venus that's a continent, one of the continents outside the Antarctic ice wall. Okay. And that's where they're from. And I don't know if you folks have seen the old maps that they don't show us anymore, but there's other continents. One of them is called Asgard, where Thor comes from. There's a continent called Asgard. There's a continent called Amazonia. That's like where I want to go. That's where all the women are at.
Yeah, I
Talking
found
about the maps of Knox
a
Compendium.
2 foot tall book in USF's basement of the library that shows from 1615 the first world atlas map of 1615. Ancient looking thing, but it has all of that plus the North Pole and all the names of every little piece of land. And then I'm gonna look in my photos and send you guys what it says, and I'm gonna send it in the chat.
There's maps from the 1500 that show when there wasn't an ice wall,
Right,
when the Antarctic wasn't frozen, and it
right.
shows pictures. I don't know if you guys the same topic. General Byrd, you guys, or Admiral Byrd, the guy who did the original investigation of the Antarctic. When I first saw those
Oh
videos, like
yeah.
around 25, 30 years ago, they showed a plane that they were going over the area where they discovered Adolf Hitler had created a military base. There was ice for hundreds of miles, and then in the middle of the ice, there was like an oasis, a large area of tropical forest in the middle of the ice. And they zoomed down closer with their plane, and I saw pictures of living mammoths. You know, those elephants that are hairy elephants with the big, gigantic tusk, the woolly mammoth. They showed
Look into the
pictures. They
story
don't
of
show it. They don't
Pritchard.
show it anymore.
Look into the story of Pritchard, where
Try to
Werner
post a
van Braun
picture of
and
that,
them
bro.
got the idea of creating space and going up where they only exceeded 72 miles up.
Have any of y'all researched the calendar and what it used to be like
Yeah,
compared to
we're
yeah,
in
that's a big. I'm still scratching
record
for
some
good
shit.
facts. Yeah, yeah.
Okay, let me see, Lewis.
Yeah.
Um,
Now, the right to travel, I just wanted to announce something. Probably next year sometime, probably spring, I'm going to be teaching seminars that would bust open the right to travel so badly that the cops are going to realize they can't arrest you. There's no there, for driving while suspended. They can't arrest you for driving without a license. All the people that have the fake plates and the DOT plates, the cops are going to leave them alone. And I'm going to be revealing the perfected distinction between somebody who's a common carrier, contract carrier, private carrier versus somebody who is using the highways for the main purpose for which they were built, which is public vehicular travel. That's supposed to be open freely to all, and that they can only require licensing of the carriers. Now, they can regulate, but see, licensing and regulation are not synonymous terms. They can regulate, they can have speed limits, they can have stoplights, and all that stuff, but they cannot require that you have a commercial driver's license. If they're going to require you have to have a commercial driver's license to taking a property without compensation, they will have to pay us every time we drive their car. If they're going to force us to have a commercial license and a commercial plate, they're going to have to pay us to drive.
Well,
It's going to
There was
blow
a
all those
guy who
people that have
did
been
that
arrested. All
named
those people that you see
KW.
been arrested, their windows busted, tear gassed, maced, hit with a taser gun, a stun gun. They went to jail, their car impounded. All of them are going to be able to sue the states for false arrest and false imprisonment.
There's a
All of them.
guy named Kenneth Yager who led a class on doing a declaratory judgment against like the state or whatever for unpaid services rendered for managing the driver's license.
Here's a good book: Police Misconduct, Law and Litigation. $2,500 just for this book. I've got a whole bunch of books on Title 42, Section 1983. Whole bunch of them.
yep, that's what we're doing, bro.
Want to know how they're all getting past the Secretary of Transportation's authority, because everybody seems to jump right past that and try to claim authority over the Secretary of Transportation, which is the top. That's all authorities delegated from him, from our author, which is the creator, to us, to the Secretary of Transportation. And then somehow the states hijack that authority because it was taken away from them in 2000 in like 2000. I think it was 98 actually or
Know
2000.
what you I know what you're talking about, Troy. Every cop I have personally confronted here in Caldwell County and in a couple others, they think that they can take.
Well,
They think
they
they have.
always quote the 10th Amendment.
Well, none of these. It's more like a personal thing. They think that, and I've got this from the sheriff and everything, that they actually think that they have power delegated so they can take like state and federal laws. And I heard, and I've still got, I think I posted a recording here a couple months ago that the sheriff's deputy said we can make them tougher. So, being said, they think they can just twist
They,
the law however they
but
want.
see,
Like,
that's the opposite. They can't make them tougher. They can make them less
right.
restrictive.
And
Right.
that's what they've been led to believe. And I'm thinking, well, I need to teach y'all the right way. I'm
Yeah,
going
it's
to.
the total opposite of what they're supposed to be doing, Troy.
Yeah, so they're doing it
Yeah.
backwards.
Yeah. And until, I mean, we got to treat them like, to me, like they treat us. Got to hit them in
Well,
that
and the fact
pocketbook.
is, everybody's using case law before 2001 when the Federal Motor Vehicle Division got all the authority. And
Right.
all the case law before that should be obsolete.
Right. And I'm going to try to make it, I want to try to go old school about it, like Carl Miller, that signature that they signed to swear at oath to the constitutions and all that. And that's going to be some of my basis. And
Well, it
here
doesn't even matter their oath. You got 5 CFR 2635.101, and they're all bound by it. And it all says in there they're bound by it. Basic obligations of public service. And
right,
Us older guys call Carl Miller constipated man.
right.
Damn. I
He
call him
talks so
Grandpa.
fast. I would stop him and say, "You trying to win a Big Mac?"
I call
Like
him
you're talking so
Grandpa.
fast, nobody can hear what you're saying. And him and I used to get in arguments when he was alive. And I said, you're so full of shit. I looked you up. Your real name is Richard Champion, the
Hey, you
champion of
said
all
which
losers who loses their
CFRs do we
cases.
need?
That's
Hold
Cam's
on.
grandpa.
That's his real name, Richard
Lewis,
Champion.
I'll
type
put
in
it
the
in the chat.
CFRs we need if we don't need to do what were the CFR codes you just cited?
5 CFR, I'll put it in the chat. 5 CFR 2635.101.
And
I want to check that one out.
Yeah,
I'm just going to stick to the Constitution, the highest law of the land. And I've asked judges or a judge last time I was to court, I knew I was going to lose. I asked him, is this civil or criminal? Well, he says criminal, but there's no damage party. So their actions don't meet the words come out of their mouth. I know a lot more now. I don't think I'm ever going to lose another court case, but yeah, they say one thing, but they're trying to do another. And when I went to, is this court under common law jurisdiction, civil admiralty? But when I said colorable, that judge came alive. He had a totally different outlook. That's when he started suggesting, which he's only been there 3 years. He's just a still rookie attorney. He started suggesting, well, I suggest you go to trial. I suggest you get an attorney. So those things that he said showed me a whole lot. So, but yeah, they don't. They're just doing by contract. This is why they don't care about us. It's all about money. I'm yield.
You just got to go to a multi-prong, like again, understanding, comprehension, knowing, not letting the court run you, knowing that they are servants to uphold. They have a ministerial duty to uphold, knowing that all power is still inherent in the people, even though that, one wants to acquiesce to, I'm a slave or we live in a slave. I live free. I know that I'm free. I maintain that I'm free. I'm going to stand as though I'm free. Even if one finds me guilty, I know within that what I am doing is proper and correct. And if I have to go through the fire to get remedy, I'll go through the fire to get remedy. I was just speaking with my mother about this recently. It's like, nobody wants to see you go to jail. And, it's like, Well, thousands of people, hundreds of thousands of people died for me to even secure my freedom in the realm that I even have right now. And so, with that being said, just in closing for today, we're pushing at 1 o'clock. We've been here since 1:30. Lewis, I want to ask, where can people find your work and book a consultation with you?
Oh, I have a book a meeting link. Let me go grab that. And I'll post that. But yeah, folks, I make my living undercutting attorneys and law firms and specializing in helping pro se litigants. A lot of people don't trust attorneys, don't like attorneys. They charge too much. They don't do any work. They hire paralegals to do all the work for them, and they put out chicken scratch for the money. Okay, so the only sales pitch I give people, look, dollar for dollar, page for page, you're going to get a lot more and a lot better legal writing out of me than you would from any regular bar attorney. And the judges hate it when you're coming into court with really good briefing. It makes them very nervous. But there's my book a meeting link. I just posted it.
And what kind of cases are you most interested in helping with right now?
I work in all areas of criminal law. I do IRS cases. I do drug cases. People that are manufacturing marijuana, manufacturing meth, trafficking in cocaine, possession of marijuana, possession of paraphernalia. I do domestic violence, assaults. I do divorces here and there. All CPS cases. If your kids have been taken by CPS, that's my big baby project right now.
That's
I
good.
have
Keep that champion, bro.
Operation Greylord. Okay. Um, I first heard about it in the mid 80s, about when I got started in this, and I was actually collecting case files out of the Operation Greylord files way back when in the mid 1980s and before like 1990. Operation Greylord, for you folks who don't know it, is the largest, most successful FBI sting operation in all American legal history. It happened in the 1970s, ran through the 1980s. It sent over 100 public officials to prison, over 30 which were state superior court judges. That's what said the tingles in the hair in my back of my neck standing up. Like, what? I thought state superior court judges were untouchable. Like 30 something plus judges were sent to prison in Crooks County, Illinois. So I started collecting case files on it. And literally within days of me getting some of those files, I was getting phone calls from strangers wanting to purchase copies of my files. And I'm like, well, why didn't you just, how'd you get my number? They said the court clerk gave us your number. And I go, why? Well, we tried to get copies of the file, and the judges, the court clerk said the judges found out who you were. I go, what do you mean find out who? And they ordered those case files to be sealed after I got copies of them. They're pissed off that I even got copies of them because I'm trouble for the court system. I don't like cops. I don't like county sheriffs. I don't like state patrol. I don't like prosecutors. I don't like judges. I hate this whole fucking court system. And the reason I got a big hard on for CPS is because they murdered my daughter in 2009 in attempt to frame me. They even applied for a search warrant to search my house to investigate Louis Ewing for the murder of his own daughter because of all the different cases I've won in Washington State, and I've helped people get their kids back from CPS. So I do have the anger. I want revenge. I want to take down CPS, and I've actually
It's,
since
it's rampant human trafficking right now, and it's just getting worse every freaking year.
And
So,
condolences to you and your daughter as well, bro.
yeah,
Sorry to hear that.
absolutely.
And I tell you, I have it 100% figured out how to take on and take down the entire CPS. I could do it all by myself if I had the financing. So what I decided to do is I realized CPS targets poor people. They can't afford an attorney. They can't afford a law firm. They can't afford me. So I figure if I create some large groups and I get these large groups formed, that I could give everybody a massive group discount where if everybody pitched in a little bit, I would take down the CPS for a whole state. All the groups are wasting everybody's time. Right now, all these different groups, mother's rights groups, father's rights group, stop parental alienation groups, stop medical kidnap groups, stop forced adoption groups, domestic violence survivor groups.
Not going to stop till we throw some motherfuckers in jail.
All these groups, they don't have a leader. Okay, I'm a member of hundreds of these groups, and I've been involved with family law since 1999. And I can tell you right now, there's not a single person in all these family law groups that has even 1/10 of the knowledge of the law that I do. Okay, they don't have the legal experience. They have nobody leading the way. They all do the same stupid shit, which makes me believe they might be COINTELPRO. Do you guys know what COINTELPRO is?
Hmm.
COINTELPRO is an offshoot of the FBI and CIA. Their number one purpose is to infiltrate hate groups, militia groups, any anti-government groups, family law groups, right to travel groups, sovereign citizen groups. These people are undercover government agents. Their number one goal is to keep all the groups divided, conquered, and fighting amongst each other. That's number one. Their number two goal is to keep all the groups on the same losing path, doing the same stupid shit over and over again, like
Voting.
holding marches, rallies, protest, signing petitions. None of those things have ever worked to bring back a single child home since 1999, with one exception. My friend Stu Peters, a couple years ago, did a shout out on Alex Jones InfoWars for baby Cyrus over there in Idaho. That's the only case where I know a protest got a single child back. Okay. They got,
Yeah, I mean, we got to protect them from even getting taken in the first place. I mean, it's
you
the only
know,
way to stop them. Once they got their freaking hands in them, it's hard.
the other thing they do, it's a waste of time. Speaking at city council meetings, that doesn't get kids back home. Speaking at county council meetings, that doesn't get kids back home. All the things they're doing, the
What do you
so-called,
think does? What do you think does?
the only thing that gets kids back home is the right type of legal paperwork. Period. There's nothing else that works.
Yeah.
And the people on the family law movement, they don't have the legal knowledge or the legal skills. Especially this dingbat named Jessica Saxton. She's a scammer. Period.
Bro.
Well, everybody in the movement is at least spreading the word that there's a problem out there. And
Can't do
so
that.
why things are happening the way they are, and the reason it's starting to grow so much is because of people like you and Jessica and everybody else that's bringing attention to
Listen.
I've had 4 people on my couch in the last freaking 2 years fighting custody battles. So
Yeah,
Well,
and
can
I
you
want to
believe
say
it?
this, and I
Can
want to
you
say
believe
this,
it?
and hold on. I want to say this.
Hey, Cam.
You know, whatever. Hold on, please. With all due respect, I don't have a personal relationship with Jessica. I don't know what Jessica does in the background. I know, Lewis, you have some kind of differences that you have with Jessica. Listen, man, my whole thought is that wherever we can come together and achieve what we are all trying to achieve, let's do it. If you feel as though she's a scammer, okay, that may be your personal belief. I don't know how much evidence you truly have, but let's just try and focus on the mission at hand, which is the people that are harmed by whatever system is in place and by the
Okay,
evil that
you
are.
and I have evidence of winning cases. We can give out court case cause numbers proving that we won cases. That proves that we know what the fuck we're talking about versus people like Jessica Saxton, who's never won a case ever.
Okay, but she's trying in her own form or fashion,
just spreads
right?
the word. Yeah.
She's trying to do whatever she can with what she has.
But you can't lead the way.
Okay, well, maybe guess what? You know, there's a lot of
That's just
actors.
her
Wait,
business, man.
okay, check it. There's a lot of actors that didn't write the script. There's a lot of musical artists that didn't write the song. Do you understand what I'm saying here, bro? There has to be a collective working. If you're part of one of it being more, look at it like this.
Then
Jessica
people like
Saxton is
her
growing.
should be
Listen,
supporting other
Jessica.
people.
Okay, listen. Jessica Saxton is growing by the thousands per day, bro.
That doesn't matter.
It does matter because how is she going to get what you and her both want if y'all don't join forces?
Good
Making a
question.
very valid point.
I'll tell you this: I'd burn my fucking library to the ground and let every parent lose
Lewis,
their fucking parental rights because
Lewis,
we're
that sounds
gonna
like
you
a
scam
don't
black
them.
then
and
you
white
don't
problem.
then you don't care about then what you're essentially saying, and not to be rude, it's all with love. But what you're essentially saying is you care less about the people than to just make up whatever differences we have. Like,
I'm
bro,
not
you
going to
gotta
work with a criminal. I'm not going to work with a criminal.
okay,
She's
listen,
scamming
man.
parents. She just admitted on her own YouTube videos that her and Tanawa Downing were using money that parents sent for donations. People that are low income, they're desperate not to lose their children, that she and Tanawa Downing spent money on drugs and prostitutes
No,
with the money
I
that was
think
supposed
what
to
the
save
claim there
children.
was, I think what the claim that, you know what? First off, hey, I want everybody just to say bye world. You know, thanks Lewis for attending. We want to say bye world. Stop the recording. Everybody unmute and y'all say
Hey,
goodbye.
yeah.
World.
Thank y'all for joining us today, man. It's been a great meeting.
Extremely
Thank
strong
you,
show.
Lewis.
Thank
Appreciate
you,
you.
everybody.
Thank you,
Very
Lewis.
informative.
Cam.